Item 1. In the above circumstances, this petition succeeds. The writ of successor issues quashing the impugned order and a consequential writ of mandamus issues directing petitioner reinstatement in service forthwith in any circumstance within 8 weeks with the continuity of service, but sans back wages, no back wages. OP number 4 managing body shall pay to the petitioner a cost of rupees 20,000 only within 8 weeks, failing which it shall pay additional amount of rupees 100 per day of dealing. Copy to be acted upon. Yeah. And I have also observed, since your contention is that the other candidate was appointed prior to your so-called quitting, let her continue if there is a so that she also will not be, her apple cart also will not be disturbed. But you argued very well. I should appreciate. Both of you argued very well. Yes.
Item 2.
Yes.
Question.
2.
Yes.
Go to the prayer for complete the ceremony suit within
The prayer for the dialect.
to be disposed of.
Yes, so the money should.
To be disposed of. You cannot keep the money suit pending for eternally.
It is of the year 24, my lord.
24.
Yes.
And we will make some observation.
Yes.
Short grievance of the petitioner. Go to the question. How many petitioners?
Picture 1.
The short grievance of the petitioners will go to prayer for as to the long pendency. The alleged long pendency of the money suit is number 1 of 2024. Pending on the file of learned senior civil judge.
Sure, my lord. So, in the district of Alassur.
It is submitted at the bar that right to speedy remedy, being one of the facets of Article 21 of the Constitution of India, in the light of the canon of decisions of the apex court, from a long pendency militates against said ideas, and therefore, a direction be issued to the learned judge of the court below to try and dispose of the subjects who should within the act expeditiously as possible. First of all. Next one sentence. The proposition cannot be much disputed. First, next, in the above circumstances, learned judge of the court below is requested to try and dispose of the subject suit as early as possible, keeping in view the seniority and urgency of other matters. First of all, contingents are kept open. The registry to send copy of this order to the OPs by speed post immediately. Okay.
Item 3.
Nonsense of increments, my lord. Similar order of my lord. I have corrected. I have already did.
The pendency of the criminal proceeding, your lordship has.
We have held that no ground at all. It is pendency is no ground for withholding.
Yes.
I have corrected.
All contentions. You put this little below. Yes. Right.
Complex.
Item 4.
May I please, Your Lordship?
Yes.
We hear the application of the petitioner for compassionate appointment made in the year 2020 is still pending, my lord, without being considered. But in the year 2025 only, the block education officer has forwarded it to the DO after a gap of 5 years, my lords, which is still pending. Your Lordship, may kindly come to
Direction to consider that.
direction.
Time bound way.
Yes, ma'am, to dispose of my application.
Prayer reads as that. Next one. Learned counsel for the petitioner submits that during these tough days of unemployment, applications of the kind cannot be kept but better. Learned AGA, Mr. Lenka, in his usual fairness at least to instruct the OP number,
Madam, OP number 3, my lord.
OP number 3 to look into the grievance of the petitioner as has been aired in the subject of representation. Representation.
No representation
No
is pending.
representation.
The application is pending.
Or is the recommendation?
Application. Application. There, where is that?
Application under Annex 3.
1 second. Application. Petitioner's application at Annexure 3.
And
In the
recommended
light of recommendation
Annex of 4.
of a BO made to the district education officer by letter dated 3/7/2025, a copy whereof awaits at Annexure 4. First off, this is appreciable. First, next one in the above circumstances, petition is disposed of 8 weeks. Delay shall be viewed very seriously. See, all conditions kept open. Okay, open to solid information, etc. Next.
Yes, obliged.
Item 5.
May I please, Lordship?
Yes, sir.
In this case, my lord, the petition challenge the order under Annexure 5, my lord.
Order.
My lord, opposite part number 2 refuse to transfer the property in favor of the petitioner, my lord, ignoring the final decree passed by the Lord and Civil Judge.
To take notice, I
Yes.
very caught in this matter because Apex Court said when there is a decree, the authorities are bound to transfer the khata. I'll impose some heavy cost. Take emergent notice. So she is requested to accept notice for 1 and 2. Emergent notice to the rest returnable within 3 weeks. First matter lies in a narrow comfort. Therefore, I just need to post it before the court immediately after service. Bring that judgment where Apex Court said the money the cost should be levied and should be recovered from the officials.
My
Okay?
lord,
I'll go to library now. Don't waste time.
my lord,
Yes.
no pleasure.
The petitioner is challenging for appointment of Shisu Sebikas in the Shisu Vatika open in the school instead of ECC teachers, my lord. My lord, in the similar matter, Lordship was placed his notice and posted the matter 2 weeks after, but it could not be listed.
Issue emergent notice.
Along with, you know, should call it along with the WPC number 24389.
When AGA is arguing, respectfully you should hear. You should not interact with FDCC, SDCC.
Sorry, my lord. Yes.
You're making submission.
Very sorry, my lord. Very sorry.
Yes, sir. Mr. Lanka, what do you see?
Is it connected to earlier Lordship was 24389/25?
For you appear for all OPs. Issue emergent notice. So and so appears for OP one first OP UOI. First, Mr. Lanka and DG is requested to accept notice for 2 and 3. First, he submitted at the bar that identical matters are being entertained by this court. Wide WP numbers.
24389/25.
I have that.
So and so. First. Next one, in view of that, call this matter along with WP number. So. Next,
May I pray, my lord, late bill fixed, my lord. 2 weeks time was given in the earlier matter.
in the third week of December. Okay. Next.
Item 7.
My lord, in the read number 30200, my name is already
Or
there.
second week of December. Make it second week. There are other matters we have said, na? Yes. Yes, brother.
May it please, Lordship?
Yes, sir.
Lordship, Lordship, this matter is related to alleged submission of fake BD certificate file. I was appointed as the assistant teacher in the government high school. Lordship, a similar matter, identical matter, the WPC 31667 of 2025. Annada Shankar Mahanti versus State of Orissa. 11th November, Lordship has directed to issue notice to the opposite parties.
Issue emergent notice. Mr. Zenkala the DT is requested to accept notice for 1, 2, 3.
Lordship,
Even headmaster.
Yes.
no, I am assistant teacher.
No. For OP number 4.
Copy number 4, headmaster.
Headmaster is government school.
Come.
Yes,
All
sir.
OPs. Call this matter along with the WP number
31667 of 2025. 31667, Lordship.
667 of 2024. Yes, sir.
Public.
Item 8.
Is your lordship will pass over the matter.
Why you just open the pages? I'll assist you. Open the pages. What is that order dated 14/2025? Annexure 6. Go to Annexure 6.
He challenges his own appointment order under rehabilitation assistance scheme, claiming that he possesses higher qualification, so he may be appointed against the group C post.
So is there any provision?
No, but there is a bar, rule 7 of
Pass
the.
over. Then I cannot dismiss my daughter's petition.
Yes.
Bring your senior.
Lordship same goes
Pass
with
on.
item 10 also.
Yeah?
Item 10.
Same. Both are same.
Same pass over.
Pass over. All. Which is the judgment of the apex court? 93 Supreme Court.
Nagpal.
Huh?
Nagpal.
That part. So just give that properly. Not 93 it is.
No, the 97 or 98.
Okay. Just give the citation. Okay?
You cannot claim any particular post.
That's what.
Item 9.
Item 9, this is my covered by that Loknath. I'm giving the correct.
Have you changed it over?
Yes, sir. Only time.
That sentence is to be completed in sentence, not this. Yes, next.
Item 10 has been passed over. Item 11.
May I please, my lords?
Yes.
Petitioner is working as a
Should
postgraduate
be appointed as principal
in
in
charge.
charge.
Yes,
What's your right to be placed in charge?
as per the seniority, my lord. Senior most teacher will be acting as a principal in charge.
Now who is placed there?
It's annexed to my lord.
Who is placed? I'm asking the question.
Yes,
Who is placed in that post?
another
Who is the
work.
junior team?
Yes, the graduation list also there.
Issue emergent problem. Matter lies in a narrow compass, posting in third week of this.
Can I submit, my lord?
Yeah.
I have, yes, I have,
Representation.
yes, in terms of office order, annexed to and seniority, that may be disposed.
What is annexure 2?
Annexed 2 is the office order that say
It
that
says
the,
senior should be placed in the in charge of office, on in charge basis.
yes,
Annexure 2.
yes,
That is 4th September 2021.
yes, my lord, 30, page number 30. And the gradation list
What is
also,
your gradation list?
gradation list, my lord, office order,
Huh?
12th July 2024.
Huh?
12th July 2024 office order. My rank is 6. Whereas the present principal in charge rank is 172.
72.
Yes.
Why he is very near to any political boss?
No. My lord, he has posted earlier. When I have transferred, I am the senior most now. I have transferred from another school. Yes.
Where is your representation? Dated?
Representation dated.
Annexure 4 series
Annexure
36.
436.
Yes, 36.
Annexure
Dated? Date latest.
date 8
9.
September 2025.
25.
My lords.
Better. Short grievance of the petitioner is as to non-consideration of a series of his representations, latest being of 8/9/2025, wherein he has sought for his placement on independent in charge basis in the post of principal. First, learned counsel for the petitioner submits that there is a government order dated 4/9/2021 which provides for placement of senior most official in the post of principal, subject to all just exceptions, and the case of infant does not fit into any such exception. First, he draws attention of the court to the gradation list dated 12/7/2024, wherein the name of his client figures at serial number 6, whereas name of the present incumbent, namely OP number,
Open number,
so into figures at serial number 170.
open number 6.
OP6. First, next paragraph. Learned DG Mr. Behera submits that in the matter of placement on independent charge or in charge basis, ordinarily the seniority fails into insignificance by virtue of the decision of apex court in 1990, so and so. First. Having said so, comma, now he submits that he would instruct OP number
1.
OP number 1 to look into the grievance of the petitioner as has been heard in the subject representation, keeping in view the law, more particularly the government, the office order dated 4/9/2021. First off, the Karnataka High Court in Basavaraj N. Dhotrad versus Chairman Karnataka Land Army Corporation. Take out that judgment. Has laid down certain norms as to how these matters should be treated. And that the authorities can draw vigilance from this decision as well. First off. Next one, in the above circumstances, petition is disposed of 8 weeks. All countries will be kept open. Open to solicit, act upon web copy. Now no course.
My lord, time bound.
Yeah, 8 weeks.
Yes.
Registry to send a copy of this order to OP number
1.
No. OP number 6.
Yes.
Yeah. Item 12. Take out that judgment where my judgment in Harvard. I said, even in charge basis arrangement, generally seniority should be followed. Take out that judgment.
Naturally, for 1 week, 4 weeks.
6 weeks.
Yes, ma'am. Obliged.
Next.
Item 12.
Yes.
That is the appointment under rehabilitation assistance scheme, my lord. I am challenging annexure 10, my lord. My rejection, my lord. The rejection, page 43 only.
Jita Luha covered.
My lord, covered. My lord, rejected in 57 point, my lord. After the
Let's notice. Okay. Emergent notice. AGA for all OPs. Matter lies in a narrow compound posted in the 3rd week of December. In the meanwhile, the OPs may file their counter. If any. Yes, next.
my lord, time.
What time?
Time. Yes, my lord.
3rd week of December.
Okay.
Item 13.
Yeah.
My lord, matter relating to vocational teachers appointment.
Huh?
Vocational teachers appointment, similar cases.
Similar matters have.
Similar matter is pending before your lordship.
Like that. Issue emergent notice. Go to the cost title. When I say notice, you should go to the cost title. Yes. AG requested to accept notice for 1 and 2. Call this matter along with WP number signed. So next. Item 14.
Well, 14 is covered by the ratio. Well, Loknath Behra.
Loknath Behra.
I'm just
survey copy on your friend also. Be kind to the government and okay. I'm kind to the judge also. You know. This one particular sentence by this one, just repeat and dispose of. Next. Item 15.
15 may I please your lordship. 15 while I am challenging the rejection of my re-engagement order dated 2/7/2025, which is in page number 30.
Why they denied re-engagement to you?
My lord, I was having been appointed as hostel warden in the year 2012 on dated 16/7/2012. Then I have been transferred to many places. Then I have been regularized also. Then what they did, my lord, due to my
There are accept notice.
My lord.
Arguable, please.
My lord, was there serious allegations?
no, my lord. May only I need to speak one line, my lord.
I'm agreeing with you now. Still you want to argue?
Not
Your senior told you to argue.
my place, my
Behra is requested to accept notice for all OPs. Matter lies in a narrow compass, 2nd week of December.
grateful.
Item 16.
grant of pension to Loknath employer.
Loknath Behra.
Madam. All matter issue notice pending.
Matters are pending, na?
Matter pending.
Issue emergent notice. Mr. Behra is requesting first notice for 1 and 2, emergent notice to 3.
My lord.
Call along with WP number. You want that number? But do you have any number of that? Yes, I know. Call this matter along with
That's okay. That's okay.
Next. Item 17.
My lord, in this case, my lord, petitioner challenged the order dated 4/8/2025 passed by the Vice Chancellor Opposition number 4 for regulation of service, my lord.
4 and 25.
My lord.
4825. 18 February 25.
Yes, my lord.
Where is that order you are telling that order?
My lord, annexer, my lord, annexer 3, my lord.
Read your play.
Yes, my lord. Pray for the lordship. May kindly there should please to read, admit the read application issue notice to the opposite party.
So from a retrospective date, you need regularization from the date of entry into service.
Yes, my lord.
Similar matters we treated what we did in matter from university matter.
Yes. Revenue University also. Yes, my lord.
Issue emergency notice. What to be first paper? Let the AGA for 1, 2, 3.
My lord.
4, 5. Issue 4 and 5. Returnable within 4 weeks. Yes.
Oblige, my lord.
Item 18.
May I please also?
Yes.
Here, my lord, this is an unfortunate case, my lord. This is the petitioners, after succeeding right from the tribunal till my lord, apex court, ultimately their appointment has been approved on Annexer 5 in 2020, my lord. And thereafter they have been brought under the fold of granting it. And after that,
take notice, emergent notice.
You also kindly your lordship judgment. They have acted in contrary. You also kindly page 56, one line, man, page 56.
56.
This is not an innocus order, my lord. Page 56. In the above circumstances, the petition succeed. A writ of certiorari is issued, quashing the interdepartmental communications dated so and so. A writ of mandamus is issued. Control of accounts, Odisha is directed to allot the new GPF number to the petition within 6 weeks. This is a clear direction. Now, my lord, they have communicated the order and the control accounts annexed 10, page 64, rejected.
Not rejected. He has asked to file, send through proper channel.
This has not been challenged to Higher Forum. And now the very same opinion number 3 rejected, that could not be granted.
My lord's Annexer 10, your lordship will find the controller of accounts has stated to send through proper channel.
No.
Yes, my lord.
Philip Kumar Devata could not be allotted
following
due to the following dates.
Yes, my lords. 1. The application for allotment of new GPF account number has not been submitted through proper channel.
They are the reasons.
That is by director.
It is a reason for rejection.
Not to resubmit. He has stated in the last para, as such application along with other documents has received letter.
For resubmission.
Resubmission.
Yes, that's why my lord, kindly say Annexer 6.
And this is order.
Annexer 6 in 2023, along with the petitioner, all other staffs, principal submitted proposal for allotment of Annexer 6 on 2023. And they have issued in favor of 6 persons.
Just take notice.
My lord.
Do something.
My lord, principal has to submit through director.
Principal submitted Annexer 6. And they have allotted to in respect of Annexer 5 persons.
Emergent notice. PG request to accept notice for 1 to 5. Emergent notice to 6. First of matter lies in a narrow compass and it is arguably covered by the decision of this court in the earlier round of the case. Therefore, first this matter in the 3rd week of December. They could not have done that one.
My lord.
Yes.
Item 19.
May I please your lordship?
Yes.
My lord, here petitioner applied for inter-district transfer in consonance to the provisions prescribed by the Assembly Department by the administrator.
All right. What happened?
My lord, now many cases have been considered, but my case has not yet been considered.
Kept pending.
My lord, kept pending before the OP number 2, my lord.
Inter-district transfer.
Inter-district transfer and
10.
My lord, annexer 10. And his spouse is also a government employee and working in the school.
So, if a direction is issued for consideration, it will do the justice.
Yes, my lord. As per the provision, my lord.
That's all.
Yes, my lord.
But short grievance of the petitioner is against the long pendency of his or her. His representation dated 2/8/2025, a copy whereof will set the next then wherein which reads as at first next one. Learned counsel for the petitioner submits that a request for inter-district transfer cannot be kept pending eternally in the light of decision of apex court in Varadhara versus state of Karnataka. Sorry. There is some force in this submission. Next paragraph. Learned ASC request appearing for the OPs agrees to instruct OP number 2 to look into the grievance of the petitioner on a war footing if all contentions are kept open. First, with this proposal, counsel for the petitioner contends. Next, 4 weeks.
Item 20.
All contentions. No.
My lord, kindly pass over this matter.
So, I will assist you.
My lord.
Come on, turn the pages.
My lord,
I want to hear your voice today. Kindly turn the pages. What is this case about?
my lord, this case is about service conditions. The petitioner prays for extending all the benefits as applicable to the aided educational institutions, like leave benefits, retirement and pensionary benefits.
Has he retired now?
No, my lord.
But the pensionary benefits can be given after retirement. Even in advance, you should be given that.
No, my lord. I'm just praying for the benefits.
Which are the benefits? Where are those benefits that is applicable to aided education 3B of the next slide? To others, sir, they have given those benefits.
My lord, this matter is covered by Jagdish Singh.
Jagdish Singh case covers this. Where is that judgment, daughter?
My lord.
You are not brought that judgment. Let judge look into those judgments. That's where what? Yes.
My lord, I'm praying for the consideration of representation.
Your is my task. You argued very well. I give some order to you. Wait, kindly be seated. Petition prayer reads as under. It is structured a bit long, but makes sense. First, learned counsel for the petitioner draws attention of the court to the representation dated, which is the date.
My lord,
6/9/2025, wherein, a copy whereof avails at Annexure 3. First one, the prayer column of the representation reads as under. Next paragraph. Learned counsel, what's your name?
Apriti Punyataya.
So and so submits that where a representation of the kind is made, the authorities cannot keep it in cold storage in view of the mandate enacted in Article 350 of the Constitution of India, as has been extensively construed by various high courts in the country. First off, there is force in this submission. Next, learned ASC appearing for the OPs. Which OPs? All of the OPs very fairly submits that he would ensure that the subject representation meets its paid within 6 weeks at the hands of second respondent. If petitioner also cooperates by furnishing the requisite information or documents. Personal. This is appreciable. Next is 6, 8. You argued very well. Why you wanted time?
No, it's anxiety, my lord.
No anxiety. I am not a lion or a wild beast or something. I am very affectionately members of the bar, because members of the bar are very disciplined. They come with preparation. Then they show a lot of respect to the court, which I also show. Is it not? Can you tell one good book on law? One latest book on law? Whichever branch?
My lord, Ratanlal Dhirajlal of IPC.
Ratanlal Dhirajlal of IPC was written when your great-grandfather was in kindergarten. Is it not?
Yes.
He has written IPC. He has written Law of Tort.
Yes.
See, latest book. I'll suggest one book to you.
Yeah.
The Aspects of Punishment. Right off. By C.K. Allen, A.L.L.E.N. He's the great author of the law in the making, law and order. Great author. Our apex court in A1 cycles is referred to his works. Okay?
Okay, madam.
Next. Item 29.
Recovery from committed value of
The consideration to take place in the light of the coordinate things with decision.
recovery from committed value of pension. This is your lordship in.
This is 22.
Yes.
21.
21.
21.
Yes. In similar cases, your lordship issued notice and stayed the recovery from the
Recovery state, Rafiq Masi.
Yes.
Rafiq Masi, not Rafiq Masi. Latest judgment, which is that, brother? Latest judgment, recovery. Brother, take notice. Same order.
In both.
Call along with other matters, sir.
Yes,
Call along with that. Yes. Both are same.
Connected by the same.
Okay.
Item 22.
My please, your lordship.
Yes, sir.
Matter is related to release of arrear salary, madam, my lord. My lord,
Salary is not released.
no, well,
Very
similar matter, my lord, already given the order, my lord. I given the corrected copy, my lord.
No, corrected it.
My lord.
So you want to write the judgment as a lawyer? I should argue and you should give the judgment now. Brother, covered by judgment. Yes. Yes, board.
Item 23.
Yes.
But here I have paid for implementation of the transfer order.
They have passed the transfer order now. 16/8/25 order.
But your lordship may kindly turn to page 15. Serial number at the top, serial number 29. I have been transferred to Panisal Government Upper Primary School.
They have not implemented it.
They have not implemented it. The block education officer is not relieving me. Therefore, I have made a representation to the district education officer. And nobody is coming to my place and
They are transferred in mind. We don't want to give effect to the transfer.
Lordship.
Who has made the transfer order?
well, at the district education officer.
And the BO does not obey him.
Lordship, this is a
Curious case.
recommendation.
No, my case was
You are
not.
not challenging.
I am not challenging.
You cannot say that. You are the author of the order. You can't say my order is wrong.
The transfer order itself,
Now, how can BO sit in appeal over the order of
No,
his...
no, that cannot.
That cannot be done. You have to take a decision in this. He cannot say, I will not give effect to order of my higher up. That will, the
And there is no
hierarchy will be violated. That you cannot do. Chain of command will be disrupted. And the rule of law will collapse.
Lordship, I may be permitted from time to take introduction, my lord, because of lordship. Suppose the vice versa.
I will call this
have-
matter. Next week I will call this matter.
Lordship.
Ray, learned ASC, on request accepts notice for OP. Matter lies in a very narrow compass. And the petitioner seeks an order to implement the transfer order. First, call next week.
Yes. The connected matter is also same.
Same.
And item number 27, along with connected matter is also same.
27, call along with this. Same one.
Yes.
Yes.
Item 24.
Well, here, the petitioner was engaged as an warden. Since he was falsely implicated in a criminal case, she was taken to custody and remained in custody for more than 48 hours. As per our CCA rules,
Automatic suspension.
automatic suspension, deemed suspension. But instead of deemed suspension, now she has been removed from service. And she approached this Hon'Ble Court. This Hon'Ble Court directed the authorities to consider my case. Now it has been rejected. You also may issue notice.
Take it. Yes. Yes. Ray, that the requested to accept notice for all of which. Okay.
Item 25.
Yes.
My lord, on board of the document, kindly pass over.
Why? I will assist you. Take the file. I will not dismiss. Take the file. Are you senior of your senior said pass over?
Pass over.
No, just read. Give over file. Take. I will not trouble you. I assure you, I will not dismiss this petition. All right, take out. What is that matter about? Is it a criminal appeal or civil appeal? Little fast you have to be, because all your friends will be sitting there in militant silence. This is what? Is it appeal, criminal appeal, or revision petition? What is this? Or writ petition?
Criminal appeal.
Go to cost table.
Criminal
Name of the
appeal.
party. Assistant. You have an assisting counsel now. Sure.
Petition for for early disposal of the regular first appeal.
Regular first appeal to the RFA.
Yes, 68 of 2025.
You want disposal, early disposal RFA?
Yes.
RFA is before coordinate bench or lower court?
Lower court.
Lower court.
Additional district judge, Puri.
Okay. In Karnataka, RFAs are always before the High Court.
Here was the earlier it was there.
What's your name, brother? Say 2 sentences about the case. 2 sentences. You can say it in Korea. RFA is pending.
RFA is
Pending. You want early disposal of the RFA?
Yes, ma'am.
But it is of 2025.
Yes,
Right.
ma'am.
The short grievance of the petitioner is that the appeal in RFA number 68 of 2025 has been pending on the file of learned third additional district judge Puri, and therefore a direction should be issued to hear and dispose it of expeditiously. First up, what's your name, brother?
Shivaranjan Pillai.
Sri Shunandan, Shunandan, what is that name? So and so, appearing for the petitioner, vehemently submits that the RFA cannot be kept pending in eternity, right to speedy justice being a facet of Article 21 of the Constitution of India. First, what he submits is broadly true. First, next one, in the above circumstances, petition is disposed of, requesting the learned third additional district judge Puri to hear and dispose of the appeal as expeditiously as possible, keeping in view the rule of seniority and other urgent matter, tendency of other urgent matters. First, all contentions are kept. All right, you argued well now. Registry to send a copy of this order to copy numbers. Go to cost table. Yeah. Copy numbers, all of this makes big post.
Item 26.
This is a very innocuous prayer from Lord's Matters. Stoppage my annual increment.
Increment is stopped.
Mallards.
Why?
Annexes 17 Mallards. That Annexes 17 Mallards kindly produce Mallards. That going for
2025.
25. And since 20, I was suspended Mallards after reinstatement in the year 1920. Then I've been getting the periodic increment till 23. Then 24 again they asked for clarification. It was clarified with the government. Again 24 they paid. Again 25 again the principal asked for clarification in 25.
Notice.
Mallards. And the peculiar fact, Annexes 17 Mallards, what their stop is why, as per the provisions prescribed, an employee shall not be eligible and entitled for an annual increment unless he completes 1 year of service. Therefore, till regulation of suspension period, he shall not be eligible for an increment.
Take note.
But during the period of, I am not claiming for that. Mallards.
Yeah. Issue emergent notice. AGA to accept notice for all OPs. Matter lies in another compass. Post it in last week of December.
Last week.
In the meanwhile, OPs may pay their council. Yes.
Last week of December.
Yes.
Okay.
Next.
Item 27 has been adjourned. And item 28.
28.
No, my lord.
28. Yes. My lord, this is a case where I have prayed for regulation of my service for the interregnum period, that is 11/7/2025 to 25/9/2025.
Your representation rejected.
No, my representation is pending under annexure.
Let them consider.
Let them consider.
Right. Petition prayer reads as that. First off, petition is presented, preceded by a representation dated 15/10/2025, a copy whereof avails at annexure 8. First off, the same is reproduced. Next paragraph. Learned counsel for the petitioner submits. Learned AGA Mr. Mohanty appearing for the worship of peace does not much dispute that the subject representation cannot be kept eternally pending. And therefore, a decision has to be taken by OP number 2 within a reasonable time. Mr. Mohanty caveats that all contentions of the parties be kept open. First, with this proposal, counsel for the petitioner is agreeable. Next part, in the above circumstance, 8. All contentions kept open. So.
These some persons are there, not more than one person. The representation is at annexure 2.
Annexure 4. You have made it annexure 4. You have not shown that annexure.
Yes, I corrected. Yes.
Okay. We'll dispose of that. Yes, you were saying something.
Only I pray, your lordship, prayer may be quoted.
Petition prayer reads as under. First, counsel for the petitioner submits that the subject matter of this petition is substantially similar to the one in WPC 27039 of 2025, wherein relief has been accorded in a particular way, and therefore similar relief cannot be denied to his client.
The period also I mentioned.
Then print this. Then.
Second case also.
Yes, sir.
Second case also, my lords. It is a similar matter. You know, grant by SCP. I corrected the.
You have corrected the.
Yes.
They are saying it third SCP, and to that effect, they have filed this representation, which is at under annexure 6.
Exactly.
I may be part.
Item 31.
Item 25.
This is item number 30. That's okay. 30, 29, 30. So 10. Yes, brother.
Item 25.
25.
That matter. I instructed my associate to make it by prayer for possible. That matter, this honorable court earlier occasion in read petition directed.
RFA, we have said that dispose of the RFA.
Well, only thing that the order passed by this honorable court, which was directed to be continued till disposal of the suit, that may continue till disposal of the appeal. Because otherwise,
you have to make that application.
That I have filed. Yes. That the opposite party is not entering appearance. That in taking that benefit.
Yes. Okay. Just wait. It hardly needs to be stated that the pending applications should be disposed of by the learned judge within an outer limit of 6 weeks.
Till a decision in
No, we cannot give
that. This order, your lordship is very well aware about that appeal is the continuation of the suit.
Correct.
This honorable court directed that.
But we are not in appeal. You are in jurisdiction.
That is there. I have got a case law saying that the honorable Supreme Court directed the honorable single judge of the High Court, not this High Court, other High Court, that to dispose of the application order 39 rule 1 and 2 till a decision is taken. This order.
Then I have to issue notice to the other side. After hearing them, we can make, because I have made a final order in his absence.
Because otherwise my application will become infructuous because to granting it.
Instead of that, we'll say within 4 weeks. Within 4 weeks.
Within 4 weeks.
Within 4 weeks. Okay. Next.
Item 31.
Item number 31. Praying for pass of your lordship.
Pass over. I will assist you. I am your junior now. Argue.
Your lordship, the conducting council is busy on another port.
You are not associated with him.
No, just
You are a
he gave me just message that please pass over the
You are
case.
a proxy lawyer.
Yes, sir.
Okay. Pass over.
Okay.
Item 32.
May I please? Well, this relates to promotion. Well, the petitioner is continuing as a teacher educator in diet mallet. Here, mallet would find it at answer 1 at page 8 mallet. Mallet one provisional graduation list was published, where his name, her name, find place at serial number 17 in page number 19 mallet, 9 mallet. Mallet thereafter mallet at annexure.
Your direction to consider annexure 4. That may help you.
May I pray, my lord? What exactly has happened? My case is that my case has been cleared from DPC has cleared it, and my file has been cleared by the concerned minister also. And for no reason it has been pending since years, my lord. Even though vacancy is there. May I pray, my lord, that file which I have mentioned, if that will be called for, my lord, may see that if
issue the emergent notice, learn the request is notice for OPs 1 and 2. First topic. The learned AGA Mr. Mohanty is requested to accept requested to produce file number, which is that?
My lord, page 21, I have mentioned it. File number SCRT OE establishment 0017 of 2021.
It's there, na? That is SCERT -OE ESST -0017/2021 for the perusal of court on the next date of hearing. First, non-production may result into levy of costs. Okay.
This can be disposed of on fresh admission.
That's what. Let's see.
Development. Okay.
Item 33.
Yes, brother.
This case, my lord, petitioner challenging the order passed by the collector cum chairman, my lord, under Annexure 6, my lord, cannot consider my education qualification, my lord.
What is that order?
Annexure 6, my lord. They have already considered other district, my lord, same qualification, but here, my lord,
Take notice. Emergent notice.
similar material.
Here it is dispute in respect of that qualification.
But for other district, you have treated that qualification as
Full file counter because CPED, MPED and BPED, that qualification.
Similar material lordship passed.
Another copy there.
Similar material lordship.
We have issued notice.
My lord.
Issue notice.
Issue notice and one post came back and manner due to
Requested to accept notice for
The copy there.
counsel for the petitioner submits that in identical matter, namely WP number so and so. An interim arrangement is made, and therefore the similar arrangement will be made in this case as well, on the principle of bearing. First off, there is forcing the submission. Next one, in view of the above, the order made in the cognate WP by way of interim arrangement is made in this case as well, mutatis mutandis.
Item 34.
May I please,
Call this matter on WP. Yes, sister.
Item 34.
34. Yeah.
May I please, Lordship?
Yes.
The petitioner before your Lordship for the appointment of the marriage register, Muslim marriage divorce register, and he had applied for Annexure 1.
One sentence. After that, another sentence. I have to process. Your prayer is called for the prayer. Direct the parties for expedient disposal and consideration of application of the petitioner for appointment of government register of mum and marriage and divorce for so and so. Which is the judgment which I had rendered? That was case relating to teachers who wanted to be
Yes,
registered.
that is different.
Okay.
That is
That
different.
is different, of course.
Yeah, right.
It is of course.
Can we direct them to consider or will issue notice?
Yes, your lordship can direct.
Petition prayer reads as under. Do you have that judgment with you? Copy of
Yes, yes. The soft copy is with me, not hard copy. That is different. They was,
I know that. I know that.
They was registered, and after
Right.
that they had teachers and similar circumstances. Your lordship dispose of them.
Petition prayer reads as under. First one. The petition is preceded by a representation dated.
No, my lord.
No representation.
No.
You have to give representation.
I had filed my petition before the ADM, and ADM also annexed to ADM also directed for an inquiry. And in the
I'll express one
Yeah,
side.
yes.
You filed the application.
present petitioner applied for marriage register, appointment of the marriage register, government marriage register
Full stop.
for Dhamnagar police station, Dhamnagar.
You have applied on which?
And applied annexure 1, 18/1/2024. After that, annexure 2, ADM directed for an inquiry to the concerned authority. Three persons: block development officer, executive officer Bhadrak municipality, and executive officer Dhamnagar NSC. And all the three concerned authority already submitted their inquiry report. Annexure 3.
They support, inquiry report support you.
Yes.
Then you take notice. I'll call this matter after 2 weeks. Okay?
They are in the process of selection.
That
Why?
process will continue till something is done, I know. Issue emergent notice. Mr. Hon'Ble DG requested to of notice for 1 into additional district, all OPs.
All opinion.
First one.
Because IGR there.
Matter lies in a narrow compass. Therefore, call this matter after 2 weeks. 2 weeks. First one. Pendency of the matter will not come in the way of granting relief to the petitioner as has been played in the petition and in the light of other contemporaneous records. Next.
Item 35.
Yes, sir.
Petition manner challenging the annexure to page 13 dismissal order.
Why you was dismissed in 4/9/2018? Now you have come before the court.
Absconded for admission.
Well, prior to annexure 2, we have filed the court given liberty to file a fresh better petition.
Earlier you had filed the petition.
Prior to only
Where is that copy?
annexure 1, page 12,
1 to 4.
annexure 12. 3-1.
Even that was 10/10/2023. Order is of 2018. You had knocked at the doors of court only in 2023. What is the explanation for 5 years? Withdrawing it and refiling it, no explanation. There itself there was a delay. Why so many years? He kept slept over the matter.
Order passed 10/10/23.
10/10/23. Well, all right. But that was the petition filed in the 2023 itself. Impugned order is 2018. What is the explanation for the delay?
Annexure 2.
Why you did not come to the court at the earliest point of time? There is delay in approaching the other judge earlier.
Given representation,
Not representation. After dismissal. After dismissal. How, brother? After dismissal, no question of representation, unless the rules provide for consideration of the representation. What is the explanation you offered? You withdrew is true. Withdrawing will not help you because in 2023 you filed, in 2023 you withdrew. But 2018 order, delay status.
After dismissal, they are unable to collect the money for filing.
Where have you stated? You have not stated. What is not stated, you cannot say from your personal experience. If you want to say that, you have to enter the witness form. I'll cross-examine you. You have not stated all that. This offhand you are saying because your teacher taught you when teaching 226, 227, 32. Petition is not structured that way. You repair the petition. I'll give you some time. Call after 2 weeks at the request of counsel for the petitioners. Okay. You make some amendments, etc., etc. Why delay, etc. Yes. Next.
Item 36.
Rushing impugned order. What is this order, Mr. Mohanty?
Here, my lord, a person who is continuing under the AG office, my lord, for regularization of their services.
How long he has served?
He is since 2003, my lord.
Then you have to regularize, na? Issue emergent notice. AG to accept notice for all of this. How many states of Odisha he wants to create in this beautiful land? Yes.
Item 37.
Lordship may kindly turn to Annexure 3 at page 22. This is a case of...
4 is the party there.
Yes, yes.
Advocate General, no, the previous matter. State Secretary.
Yeah, you appear for all of them. Yeah.
Well, this is a case of mutual transfer. The Lordship may kindly turn to Annexure...
Implement transfer order.
Yes, there is a transfer order. Well, so far as the petitioner and opposite party number 4 are concerned, I was relieved by the district education officer.
You take notice.
Because I will take notice, and well, the difficulty is, well, the opposite party number 4, she has filed a writ petition, that is WPC number 1.
Call along with that.
Along with that,
issue emergent notice. Mr. Mohanty is requested to accept notice for 1 to 6, emergent notice to 7. First, call this matter along with that WP number
15316 of 2025.
Filed by OP7.
OP7.
Filed by OP7. Yeah, next.
Item 38.
38, your lordship, a short pass over, your lordship.
Why pass over?
Senior advocate.
Turn the pages.
I have filed an IA, your lordship,
Yes. What is that IA?
for appropriate orders.
What appropriate? I will say appropriate orders are passed. Will it help you? Yes. What is that appropriate order?
To direct the opposite parties to take.
Kindly have a look to the prayer of the petition. The property of the
to cause that why the police shall not be
directed to protect from taking over the possession of the case property belonging to the petitioner.
Case property. This property included in the case.
Yes, relating to this case.
Not to take the property.
You want to take the property, but
You want to take the property.
no, the property belongs to one Ortha Tattva, Pradeep Sethi. Ortha Tattva that who is cheating the people from collecting money and invested in some properties. This property was under sub judice.
Economic offense. He is in custody since couple of around 8 years.
In whose custody?
Economic wing custody. Some
Series of cases.
No, but it is her property.
No, he says that is a, but the root is here. Money is invested in this property.
Huh?
Money is invested in this property.
By who?
By the Ortha Tattva people. They have purchased it from the real owner. And thereafter, my lord, some 2 to 3 transactions were made. Finally, it has come to her.
No, I do not understand.
My lord, Mr. X
Yes.
is the real owner of the property, from whom the Ortha Tattva people purchased.
Why purchased?
Why purchased? He is a financer, small scale financer. He purchased the property. He invested in that property.
Yeah.
Thereafter, when these police people came and some sieges were made, they have started transferring from one person to another. Probably she is the 3rd or 4th purchaser.
I'm the 3rd purchaser.
4th purchaser.
3rd.
Third purchaser.
3rd purchaser.
You purchased that property.
Yes, from Hidmaya Panda. No.
Which is that
I
property
purchased
from?
Ortha Tattva people.
That company was registered in the name of Ortha Tattva. Being the managing director of Mr. Pradeep Sethi, who is in custody for a couple of years.
No, that's a
series.
the custody.
That is Ortha Tattva.
Where is the prohibition for a citizen to buy the property?
My lord, there is no prohibition, but the money of the poor people were invested in that.
That's all right.
Yes.
Whatever he buys.
Knowing fully well that.
No, where is the prohibition?
No, there is no prohibition.
Yeah.
There is no prohibition, but property is in dispute and is with the police people in the investigating agency. CBI is also investigating that.
You are not catching the point.
I'm catching that, my lord. Your lordship wanted
prevent a citizen from dealing with a property in dispute. Where is the law? It will be resplendent at the most.
Yes.
She is entitled to have the registered document.
She may have, but the property involves so many persons' money. That is in dispute. She may purchase so many properties as she can.
Yes.
There is no bar in giving her possession. She may possess, no problem. If the police will give them, they will purchase. But when the time of sale will come for payment of those money, then she will be in problem.
She is wise enough to know what should be done for protecting her interest. How can state advise her unless the state has power?
No.
Advise the city.
My lord, it is our duty to protect the interest of everybody because they are the citizens.
Suppose that, all right, if I cook a bad food in my house, can your police enter and say, no, it is our duty to protect your interest, therefore you should permit me to cook a good food? The doctrine of parent patria, can you stretch it to that extent?
No.
Suppose if somebody is smoking on the compound of his house, smoking is bad for health.
Yes.
Then the police come and snatch away the cigarette.
Yes, my lord, there is a smoking area is
That's what I said in his compound.
Smoking area is decided.
All right, he is doing that.
He will be penalized.
Question is not that. It's not that simple. It requires consideration. Which is the law which says a property involved in a criminal investigation shall not be bought by anybody. Unless, for example, section 52 of CPC. The property in dispute ordinarily shall not be transacted during the pendency of the dispute. If somebody transacts, it is subject to outcome of the suit. Where is such a law in criminal jurisprudence?
There is no law.
Then what is maintainable? Merely because so many people are saying that we have put into our money into Mahanadi and therefore nobody should take Mahanadi water. That will be too broad a proposition.
My lord, let's not call this matter, let me call them.
Just look into, you also study. Yes. There is one judgment of Apex Court in 1962 or 63. There is one judgment of, there is a judgment of Calcutta High Court, AR 1949, Calcutta. A man can do, in other words, a natural person can do all that is not prohibited by law. A legal person can do all that is provided by law.
Yes.
So beautifully they have written 49 for the Calcutta Weekly Notes, AR 1949 Calcutta. Unless you say law which prohibits a citizen from dancing on the street, you cannot interfere. Bring that judgment.
Okay.
That judgment is referred by 3 judge bench of Karnataka High Court in a hijab judgment. Okay? Just bring that. Yeah. Reluctantly adjourn to week after next.
Yes.
Yes.
Item 39.
The petitioner before my lords is a registered society, my lords, and the petitioner was given custody of about 162 cattle in an injured state, which were rescued by the state authorities. Yes, my lords, they were rescued by the state authorities. They were being carried in 6 carriers, my lord. There were 6 containers. Total cattle was 388, out of which 40 died. On the last date of hearing, I had requested my lords to see the state in which the cattle was handed over to me which is the PDF page 309, my lords.
No,
And it was very moving. Yeah, that's the reason I didn't want to trouble my lords again. Yes, my lords, I don't want to trouble my lords again with that.
I remember.
Yes,
I
yes.
just cannot say
Yes.
something is obnoxious, therefore I cannot see. I have to see and decide.
Yes,
the
no,
matter.
but my lords
Not
had
it.
seen it last time, and so I don't want to trouble my lords again.
That-
So, my lords, may just straight away come to page 24. That is the requisition letter by which I was called upon to take charge or take custody of these cattle and was also assured reimbursement of the expenses which I would incur. My lords may come to page 24.
24.
Yes, my lords. It's a very small letter, if I may just read. With reference to the case and subject cited above, my lords has it.
Yeah.
I am to inform you that 388 cattle has been seized yesterday, that is on 12/10/2019, near the village so-and-so, from 6 number of contingent which were transported in a very cruel and inhuman manner. It is not possible to keep them at PS. Hence, it is requested to provide shelter to the seized cattle, and the necessary funds will be provided for their care and maintenance by the district administration as soon as possible, as per the telephonic conversation with Sub-Inspector Malas. This was the...
Who sent this letter to whom?
Manas, this letter was sent to, if my lords may just see at the top, the President Shri Gopal Goshala. That's the petitioner before my lords. So, and my lords, this was sent by the police, my lords. Nihal Prasad PS, IIC Nihal Prasad PS.
To the police.
Yes, my lords. Yes, my lords. And the assurance. I'm sorry.
What you want? What this letter says?
Well, now the status is that the cattle has been in my custody for 2,223 days total, and all I have been paid up till now is only for 23 days. And
to pay.
Well, it's the state administration which has to pay.
Law?
I'll just place that law. My lords may come to page 7, which is a part of the petition.
Page?
Page 7, my lords. These rules are reproduced there.
Are you a registered association?
Yes, my lords, I'm a registered society.
Registered under?
My lords, it's Society Registration Act.
1860.
My lords. My lords, may come to page 7. My lords, I'm also affiliated by AWVI, my lords, which is Animal Welfare Board of India.
Under the Prevention of Cruelty to Animals Act.
My lords. 7.
You wanted me to...
My lords, I was requesting my lords to come to page 7, my lords. That's where the relevant law is reproduced. My lords may come to the last three lines just before it starts short title and commencement. Page 7 of the petition, Court Master, sir. My lord also has been given the Bear Act. Page 7, my lord has it.
So do you answer the definition of animal welfare organization?
My lord, yes.
You answer that?
Yes, my lord.
You answer that?
Yes, my lord.
Read that.
My lord, just
2B. Animal
welfare
for the other side.
We are there.
Ready with the matter.
Yes.
Yes.
My lords, on the last date of hearing, my learned friend had taken time to take instructions.
Mr. G.
My lord.
Do you dispute that the petitioner answers the description in Rule 2B? Why are you not making a payment?
My lord. Let us submit, my lord, thereafter.
Yes.
May I say, my lord, last occasion,
He was there.
Yes,
clarified.
so for the purpose of care and maintenance, that rule, so it has been seized in 2019, around 388 cattle near the village under the district of Fort Bengal.
Slowly.
Exactly.
They have seized.
Yes, ma'am.
But do you find fault with the seizure?
No, ma'am.
No.
No, we are not in dispute. We are not in
perfectly
dispute.
done.
Exactly. We have taken care of also that cattle.
You have taken care of those cattle?
Yes, ma'am.
Seized
For
cattle.
that, they have been paid also. No, my lord. Gosala has taken care of that cattle, injured cattle. For that, district administration has taken note of the same and also paid certain amount.
How much money you have paid?
Amount is
days.
6,86,000.
How many cattle? How many cattle?
162, man.
162.
Yes.
Normatively, for each cattle,
Yes.
what is the fodder price?
The fodder price
So
for
far as
the
Odisha is concerned, it is 1600.
1600.
16,000.
16,000 per year.
Yes, if I may just intervene, manage the rates are prescribed 200 per day per cattle.
That is government, central government.
Page 332, Malan, 322. These are the rates prescribed by the Animal Welfare Board of India, Malan.
Rule?
This is
How much?
322. If my lords, yes, my lord, 200 per day per cattle. May I just place the statutory provision before my lord, subject to my lord's permission? My lords, I was coming to page 7. 7 is my lords. These are the.
Can you cite one best book on prevention of cruelty to animals, which is the best book on that? I have not read. I will read.
Would my lords permit me to allow me to come back on this, my lords?
If you suggest one book,
There is a suggestion coming from my learned friend, Menika Gandhi. There is one suggestion coming from my colleague.
Animal laws.
Yes, my lords.
That is the latest compilation.
they are not.
Menika Gandhi.
They are not applicable to men. There's a famous statement by Jeremy Bentham in his Principles of Legislation and Morals, Theory of Legislation and Morals, where he said, laws address only men, not animals, dates, and calendars. A law relating to prevention of cruelty does not give any rights to the animals, but imposes obligations on humans.
Yes.
Very famous statement.
Yes, my lords.
Just give that. I will read. I don't have much exposure to this branch of law.
Give it to the.
But I'll read it within. I will have it within next week. We can have, because I have to read. I need some time. No?
Yes, my lords.
Give one book.
So,
I'll return.
As convenient to my lord.
Yeah. But that is how these cases are treated by various high courts in the country.
My lords, this case really requires some authoritative pronouncement by my lords, because my lords, law on this is completely lacking. We tried our best to, trace a precedent. There are no precedents, my lords, and the law otherwise, the statutory rules which prescribe for this are so clear. If I may just place them before my lords, and my lords, the provisions are such that interest of the state is also adequately protected. Now, if the state doesn't do that, that's a different thing, my lords.
No, state generally, any state government will not do it.
It's interest of the state is protected, my lord.
Generally.
Interest of the state is protected at the cost of the accused, my lords.
My lord, we have.
Because in this case, there are three parties involved: accused,
So-
state, and my lords, the goshalas.
Anybody is convicted under the act.
My lords, convicted. Convicted.
What is the nature?
Yes.
What is the nature of penalty?
My lords, the offences under which FIR was registered were 379.
You say
Yes, my lords.
it's only 379.
No, it's 379, 411, 427, 429, 34 IPC, and 11 of Prevention of Cruelty Act.
Prevention of cruelty.
Yes.
Is he convicted under the provisions of Prevention of Cruelty Act?
My lords, is he convicted?
Convicted under which provisions?
Convicted, my lords. He is convicted.
Convicted under which provisions of which law?
My lords, I'm sorry, but I'm not clear on this. I think I'll have to take instruction on this, because the state should be able to answer, because it's the state who's pursuing the.
I want it.
No, we are not pursuing. You are pursuing.
No, I'm not. It's not on my complaint.
Anyway, okay. There are some judgments which say where cow slaughter takes place.
Yes.
Because cows, cattle are very important to this country, because this is an agricultural country. Only with the cow dung we can enhance the fertility level of the soil. Nothing by nothing else. Only the cow dung. That's what the agricultural sciences says, because I handled some matters which on the other day in Bangalore. So without cow, the agriculture would be affected. And Supreme Court said in 3 judgments, agriculture is the lifeline of this country. These are the words of the judgments of the Supreme Court. Therefore, it is not just cruelty to the animals. There is larger thing, because our culture is associated. Our civilization is associated with cows, cattle, etc.
That's right.
Okay. Therefore, we say Gomata, Gomata. In our scriptures, we say Gomata because when mother is dead, a lactating mother is dead.
Yes.
The cow's milk is given. Therefore, she is Mata. All right. Whatever it be. There is law no. There is prosecution. Trial having taken place, conviction has been entered. I assume, I do not know much, subject to correct me.
Yes, Manoj, that's something I would also need to verify, Manoj, subject to what
Not
they...
inherit my sentence.
Yes, I'm sorry.
Resist yourself from what we. Now there is a conviction. There is one judgment by Shashikant Dixit of Allahabad High Court, where fine is levied. That fine amount should be used for these things. Whether such a provision is there in your state?
Yes, my lord. These are the statutes, my lord, which I wish to place before my lords. And it's only on the strength of that I'm saying that the interest of the state is protected.
So it is not that they are paying it from their pocket.
No, my lords. They're supposed to take a bond from the accused, and even the vehicle which are recovered, they are also to be yes, my lord.
Proceeds to be appropriated for these.
That's the provision. So my lords,
give me short adjournment.
I'm sorry, my lord.
Please give me a short adjournment. Update myself and come back.
My lord's convenience, absolutely.
Next week, can I have it? Next week. How big the book is? The animal law compilation, how big it is? How many pages?
That is the compilation of so many laws, but this prevention of cruelty to animals is a small book. I'll flag
this
and I'll
the main time.
No, give full book.
500.
Don't flag any pages. Just give that. How many pages?
500 pages.
While my lords are at this, my lord may also read the Bear Act, which my lords have just given in.
I'll read.
Yes,
give me 2 weeks. I'll update myself and come back. I'm sorry for taking the adjournment. Judge should not say that he will take time to read and come back. But I'm not much exposed to this provision of law.
Would my lord permit me to appear virtually, my lords, in case...
You are coming from which place?
Yes, I'm coming from Delhi.
Thank you so much for
I'm
coming
so grateful.
assisting that court. Any day, any other day, you can argue online also. Yes. Item 40. Which date you want?
Well, it's first week of December, subject to my lord's convenience.
First week, I'm likely to be away from
because
of some functions.
Okay, then.
So we'll have it in the second week of December. Second after 10th. After 10th.
After 8th.
10th of 10th. I will be.
The week starting 12th is
12th.
12th. No, not 12th.
We'll call this matter on
12th.
16th or 17th.
17th should be fine.
17th.
I'm so grateful.
Thanks.
I'm grateful.
Yeah.
Item 40, my lord, where 2 sets of counters have been filed. One by opposite parties 1, 2, 3, another by the opposite party number 4. My reply is almost ready, my lord. It can be listed next week so that I'll be able to apply.
Because of my lord interim order, the school is not managing.
My lord, 3 days time.
Not completed argument.
No, but 3 days time. I have stated in my counter that they have no locus standi whatever to challenge that. My lord, I need only 3 days time. I prepared. Everything has been ready.
Because the school is going to fill up the form because of stay order, my lord. There is no managing committee.
No managing committee.
My lord. Because of stay order, my lord, school is
15, 12, we can have this.
My lord.
15.
Any short date, my lord.
It may not reach, I can post it, but will not reach. Therefore, 15th, you can mention if it does not reach. You can mention it.
Yes, madam.
All right. Yes.
Yes.
Yes, sir. Passos.
Item 41, my lords. So we have filed an application IF for withdrawal of the FAO, my lords.
41. This is 40.
41.
41.
We have no
Just for the first submit.
First matter.
Appellant has filed a memo or application.
Interim application, my lords. 9 to 9 of 25.
Seeking, leave of the court to withdraw the subjective FAO. First, learned advocates appearing for the other side signify their consent for front of each. First, next person.
Your Lordship, the third submatter, we are not withdrawing.
No, whichever is withdrawing, that matter.
Yes.
There's no connection.
That
Third matter has no connection.
FAO 319.
Yes, ma'am.
Find 347.
So I'm the first one.
You are
319. Yes, madam.
I wish that you were there in all the three matters. FAO 319 of 2019. Application is no seeking leave of the court to withdraw the appeal. First off, there is no objection from the other side. First off, in view of that, in view of the above, application is disposed of as having been withdrawn. With no liberty.
Second one may also be permitted to.
You want to withdraw that also? Not happy with the court?
The both are connected.
Well, 192. That is FAO 347 of 2013. 358 of 2013.
347 is a disposal.
Disposed of matter it is.
Already.
319 is 358.
358 of
2013.
Yes, 358 of 2013. Same one.
319 is a different.
Yes. The third submatter.
319 is also withdrawn.
No, it is a different.
No, my lord.
351 is withdrawn.
2019, my
Not
lord.
withdrawn.
Not
My lord.
The application for withdrawal.
Lordship.
My lord, 319 of
The year of 2012.
2012.
The pending matter 2019.
Yes.
Okay. Then that will be.
Last
Not connected.
Not connected with the other two.
The matter of 2019.
Disposed of matter.
It's not disposed of, it's pending.
No, but please, brother. Which is the appeal you want to withdraw? FAO
319.
Lordship 319 of 2012.
9 of 2012.
319 of 2012. And
358 of 2013. 319 of 19 is still continuous.
Last one you can.
That is a different matter.
We are no way connected.
yes.
319 ଟା ପରା withdraw ହେଲା
Please, your lord. These are the numbers summarized.
Different matter.
You're all good.
Strongly tagged. 19 is the difference.
Wrongly taken.
It has no connection with it.
Cases to be detagged from each other. What do you mean? Huh? Can I come back within a minute or two?
Which oblige?
Permit to withdraw.
Permitted to be not happy with the court.
No, my lord. Highly approved.
I am for the opposite party in this case, Lordship.
Yes. Do you object to withdrawal? Yeah.
Item 43. Item 43.
For withdrawal, I waited to dispose of that as you withdraw in terms of memo, we treat as a next. Yes, he wants to withdraw. You object to that? No. Which is the judgment of the apex court, which said right to litigate includes right to withdraw the petition.
This matter was in fact already argued at the time of. I'm so sorry, I beg it to this matter. I beg.
No, Mr. Ratho, just tell me, which is the judgment of the apex court which said right to litigate includes right to withdraw the litigation launched? Right to litigate, right to file a case.
Yes.
Includes right to withdraw the case, which is that judgment, famous judgment, which is rendered by Justice M.N. Venkatachalaya.
Yes, yes.
Apex Court.
Yes, but can
Send that.
it take a while to?
Yeah. Okay. It appears as Sheila Bakse was the state of Maharashtra, state of UP. There are many Sheila Bakse cases. One such case said like that. Yes. This board.
Item 44. On behalf of Ulas Kumar Mahanti, let us next week, my lord.
This is the matter submitting.
2021 matter.
Yes.
I am for appeal. On your Dilip Kumar
Last date
Mahapatra.
also-
This is not deal, my lord. This is not the health condition is not good, my lord.
Lord, your lordship has already argued, heard the matter. Lord, that review, your lordship may kindly remember that review disposed of. They are connected to review. Same issue involved here. Lord, last date also Mr. Mahanti took time on the ground of health.
Yes, case is 2011 matter. I am not giving time.
Nothing to do with this review. I am there in the petition, some of the cases. If Mr. Mahanti will argue later also, because he's asking for time, I don't know.
Why, brother, time you are seeking time again and again? 2011 matter. What people will say when you go for walk?
My issue is 2007 also.
2007 also?
Yes, that is the oldest.
Next week, any date.
Last time also you said same thing. We give time. And Mr. Ratho was angry. Why are you giving time again and again in old matters like this? And the justification again and again, how long I can give time? This is perhaps arguably the oldest FA. Well, not your senior is not well.
Not well.
Not well.
No. He doesn't want to, because in view of the lordship judgment review, he doesn't want to argue the matter.
No. Review has nothing to do. This case review I was argued by me, not by Mr. Mahanti. Not by Mr. Mahanti. This is a case. This FA is maintainable. So let me argue.
Have some issue has been dealt with the
No problem.
Elaborate.
By saying all these things, my lord, I cannot develop them. But I will place my case if my lord permits me. If it will not agree.
No, because in the absence of
saying something that I cannot.
The final date.
Let's my lord.
Call this matter. Finally.
Sometime
around 26, 27, I will be absent. 3 days.
November
26,
next week.
Which November? The last week I will be absent. That is my problem.
18,
Next
19,
week
20.
or next week after.
25 we will.
No, 25, 26, 23 days I have problem. I will not come.
26,
I will not come. Yes.
24th will do.
Monday, not
25, 26, 27. If it will finish, is all right. I am ready for other. 3 days I will be absent.
24 all right.
Yes, 24 I am here. No problem.
Call this. But this old matter.
But if it will be carried on to the next date, my lord, then no problem. 3 days I will be absent. My lord, that is.
Now he is threatening me that it will spill over today.
No, they are saying 2 p.m. So if it will not complete it, then.
Let's not estimate on my lord.
This we will have on 10th of December.
My lord.
Lord, 10th of December, my lord, my humble request to be, humble request to be, my lord, can it be on 28th or 17, 18, 19, 20? Any time, my lord? Any time.
20th all right?
Yes, next week I am there. 20th, no problem.
Finally.
I am there. No. If my lord want to hear me also.
Yeah, we will hear you also. Unless you don't want to argue.
I am always ready when. I hardly take time. Half.
But bring my judgment also.
It's here, Lord. It's
Who is judgment? Not his judgment.
Item 45.
My lord, item 35. Some time.
What time? 2018.
On the last occasion, my friend took time.
No. My lord, I devoted all time in item
That
40.
matter which you had argued. I have protected interest of your client also.
Oh, nice.
Yes.
Last occasion, my friend took. That is a my client retired from service. That is a pensionary benefit. Last occasion, my friend took time.
Generally, the government advocates will have a lot of pressure because I pressurize them and the officers pressurize in another way. They don't cooperate. We'll give one short date. Okay,
my lord. Our date may be fixed.
All right, we'll fix a date of 10th of December.
10th of December.
Yes, 10th of December. 10th of 1 second, brother. It will be 11th of FAO. Thursday. Yeah.
Item 46.
No. Your lordship may kindly see the order dated 18/9/2025.
18/9?
Yes, sir.
କଣ ସବୁ କଥା ଜାଣିଛ ରେଡି ହବ ନା ଆଉ ଆମେ କଣ ତାକୁ ସବୁ ଗୁଡାକ
information. And then the next day, this is copy thereof. So who appears for the institution?
I am applying for the information.
Where are the documents? Where are the records? You were supposed to say now how salary is being dispersed to all the employees.
This is policy by the Hon'Ble Court. Not with rules.
But which means you only have to produce that.
Yes.
Who is OP number 3?
Yes,
Institution.
And therefore, I am appearing.
OP number 3.
Yes,
But where is the information which you have sought for? Issue arrest warrant. So who is your principal? You let us arrest him for you take instruction for release. This court-wide order date. No, I will not permit that way. This is a court. With court orders, everybody has to bow down.
And that is the tenor of that order.
Yes. This court wide order dated 18/9/2025, after hearing the parties had said as under. Next paragraph. Despite warning that on the next date of hearing, heavy cost may be levied on the management if mandate is not complied with, the management of OP number 3 does not care it. First off, this conduct on the part of the OP number 3 is an affront to the judicial process. First off, next paragraph. In the above circumstances, who is the police? Which SP? No. Which is that SP? Who is that SP? Arrest the chairman of the managing committee. Let him be arrested. Let him should appear in this paper so that others will be alerted. The superintendent of police, which is that?
That is Mayurbhanj district.
Yes, superintendent of police so district is hereby directed to arrest and produce the chairman of the managing committee. And in addition to chairman, a secretary is also there?
Yes.
Chairman and secretary of the managing committee.
Principal cum secretary.
Only the secretary is
secretary is the opposite party number 3. Principal cum secretary.
No, what I should do with it for not complying? The secretary.
Principal cum secretary.
Principal cum secretary. Secretary and producing it for the court on the next date of hearing. No court below shall entertain any bail application if moved by the said secretary. Call this matter on 20th of this month.
Free copy may be given to the state so that they can.
To share a carbon copy of this order with the learned AGA Mr. Behera for implementation. Yes.
That was my not second permission. That absolute withdrawal right of withdrawing a case, absolute power.
Which is that?
That I remember, Abra Khan case, this honorable court.
No, that was under order 23 rule, not that. Not that. Independent, the horse 23(3).
Yes,
there is such a
withdrawal or abandonment of a claim. Withdrawal or abandonment of a claim.
That was under order 23(3) of the CPC. But this is divorce 23(3).
This is writ petition.
Writ petition. Therefore, divorce 23(3).
That Trinaz Basant Rai deals with the issue. I'll give that slip to my lords.
Apex petition? No, I want apex petition. Apex petition of Justice M.N. Venkatachalaya.
I'll give that.
Just give that.
I'll give you a slip.
46.
Your lordship directly not at a spot. In fact, what the hear me for a moment. I bow down with the Lord. In fact,
I have lost contact because the person who had engaged me is no more in job. Your Lordship may give me a week's time. If I fail to comply, Your Lordship may pass it.
Next.
Your Lordship may note that I have prayed, but at least I will be safe.
Counsel for the petitioner seeks
No,
time.
no, I am
not petitioner. Counsel for the
Opinion number 3.
seeks time for complying the order. No time can be granted in matters which involve an affront to the judicial process. Yes.
Respondent number 3. Respondent number.
Opinion number 3.
No, it's an appeal, so respondent number.
That's fine. Opinion respondent.
Respondent number 3.
It's an appeal.
Item 47.
Yes.
Yeah.
My lords, item 47, next to it, your lordship.
47.
My lord,
I succeeded before the tribunal.
in fact,
My lord, I succeeded before the tribunal, but I am not enjoying the fruit because of the pendency of this appeal.
Yes, next week you are doing that, Mr. Vera.
my lord,
No, we'll have it on 11th of December.
my lord.
On 11th of December, at the request of Mr. Behar. Finally,
Yes.
the request for further adjournment shall not be entertained. Yes.
Item 48.
Yes. Yes.
My lord, this is a case where I have challenged the order of the State Education Tribunal. My lord, may kindly turn to Annexure 8 at page 23. Yes, that is the impugned order.
What is the make a statement of the case?
Well, the statement of the case is the appellant was appointed as an assistant teacher on 27/6/1988 against a trained graduate post. By then she was an untrained graduate. She has not acquired B.Ed qualification.
One second. What's your prayer actually?
My prayer is to approve my appointment and release granting it.
You were appointed on?
I was appointed on 27/6/1988.
As?
My lord.
As what?
As assistant teacher. My lord, on 28/7/1990, the secretary has also issued an experience certificate in my favor. 28/7/1990. An experience certificate has been issued in my favor by the secretary of the managing committee. Then on 16/8/88,
you are going reverse here. You are going in reverse here now.
Yes.
16/8/88.
My lord, the resolution was passed by the managing committee that since I have not acquired B.Ed qualification, so because in addition to my duties as a assistant teacher, I was also kept as headmaster in charge of that institution. On 16/8/88, the managing committee passed a resolution that since I have not acquired B.Ed qualification, I should continue as an assistant teacher, and another person was
appointed
as headmaster in charge.
16/8/88, you were continued.
Yes. And they passed.
In fact, you were removed from the in charge from the post of principal.
I am also not claiming for that. Then another resolution was passed on 1/12/88, allowing me to continue as an assistant teacher.
Allowing you to continue. Why is that question arises?
Well, 2 successive resolutions have been passed by the managing committee. That I have annexed.
16/8/88 and
1/12/88. That is Annexure 3 at page 14. Then I went for B.Ed training and I acquired B.Ed qualification in 1994, in July 1994. Then I submitted my joining report on 25/10/1994.
Joining report means you were kept out of the employment.
No, my lord. I took leave and I prosecuted my B.Ed course, and after completion of that course.
Sabbatical and you completed this.
Thereafter, I submitted my rejoining report or joining report.
Joined on
25/10/1994. Annexure 5.
24/5.
25/10/1994.
25/10.
Yes. Annexure 5. Then, when the managing committee did not recommend my name for approval, that is for the purpose of release of granting it, I made representation to the director on 17/10/96. Then I approached this honorable court. This honorable court passed an order that you approach the State Education Tribunal. That writ petition was.
That is 24B.
Yes, but the writ petition was filed in.
That's all right.
97.
Took it under section 24B of 1969 Act.
Yes.
Yes.
That is OJC number 17786 of 97. That was disposed of on 7/1/2008.
OJC
17786 of 1997. Disposed of on 7/1/2008. I have quoted that order.
1 second. OJC 17786
of 1997.
Disposed of on
7/1/2008.
11 years.
Yes.
Saying
that you approach the tribunal. That case was transferred to the tribunal. I'm sorry. That was transferred to the State Education Tribunal.
Is not OJC before the tribunal?
No. OJC is before this honorable court. Original jurisdiction case. Referred there. That order I had put it on 7/1/2008 after 11 years. And VA case number was registered.
Do you have a deadline with you?
No, deadline.
Date chart you don't have.
I don't have. These are the dates. These are the only days. Thereafter, that case was registered as GIA case number 87 of 2008.
No, what I don't understand is,
yes,
having kept the matter for 11 years here.
But I am also surprised because in view of the judgment of the Honorable Apex Court, it should not have.
87 of 2008 you filed.
Yes.
This is the
not changed. That was renumbered. After transfer, it was renumbered as
transferred.
Yes.
As
GIA case number 87 of 2008 because it was transferred in 2008. OJC was filed in 97.
Correct.
But thereafter, my lord, the tribunal, my lord, without any findings, my lord, rejected my case under Annexure 8.
Order you had sought for at the hands of the tribunal.
My lord, I sought for approval of my appointment as a trained graduate teacher and to release granted it in my favor.
What tribunal says?
Tribunal says that I did not file any papers before the tribunal that I was regularly appointed against an admissible post. That is the only findings.
Where is that order?
Well, at page 23, Annexure 8.
Very short order.
Very short order. The applicant, who is working as an assistant teacher in Bella Somalia Girls High School at Bella Somalia in the district of Bhadrak.
How you were appointed? Selection process took place.
Well, selection process was there, and there is a resolution of the managing committee.
Where is the selection process?
Selection process, selection process is with the management.
Where have you pleaded?
Well,
that I have been appointed.
Yes,
undergoing the selection process.
Yes, I have pleaded.
High school. High school যদি আসছি কোনটারে হবো 8781 এ আসছি advertisement হয়েছে
It does not appear to be placed.
Yes. But so far as selection process, my lord, I have not indicated specifically, But there is a resolution of the managing committee because your lordship
That
knows.
only says continue.
No, resolution is there.
Resolution.
No, resolution is relating to my appointment.
You're appointing you to the
Because,
post.
my lord, in an unaided school or in an aided school, the managing committee passes the resolution first and thereafter any order is to be issued. So resolution is the main thing.
For appointment should be preceded by selection process.
Yes. Yes, yes. That is correct. That is correct. My lord, although I have not specifically stated.
Anywhere in the red papers.
Yes.
In these papers.
Yes.
Though not you have pleaded. Anywhere there is indication that your appointment was preceded by selection process.
My lord, your lordship may kindly see the resolution.
Resolution.
Resolution, that is in vernacular.
Kindly read where it says, read those words.
My lord.
Selection process. Equivalent word is in your Oriya. What is that word? Terminology.
Niyukti Prakriya.
Niyukti is appointment. Selection.
Choyana Prakriya. Choyana Prakriya. My lord, may kindly see. I'm just
show that word from these resolutions.
Yes, yes. My lord, प्रथम प्रस्ताव गत 27/6/88 रेखरे अनुष्ठित अधिवेशन विवरणी पाठ करा जाई सभापति द्वारा अनुमोदित हेला। द्वितीय प्रस्ताव गत अधिवेशन तृतीय प्रस्ताव सुपारिश क्रमे शिक्षक तथा शिक्षयित्री नियुक्ति संबंध रे उप कमिटी सिद्धांत अनुसार that is the subcommittee was constituted and for selection.
Very good.
उप कमिटी सिद्धांत अनुसार
सिद्धांत अनुसार means according to procedure.
Yes.
What is the selection process?
Because one subcommittee was constituted for the purpose of selection, and on the recommendation of the subcommittee selecting the petitioner and some other teachers.
Where is that recommendation?
Well, that recommendation I don't have, but in the resolution it has been indicated. उप कमिटी सिद्धांत अनुसार 3 जन शिक्षक और शिक्षयित्री को संपादक विद्यालय पाठदान कार्य नियुक्ति देइचंती। सेमानक मध्यरु कुमारी रमामणि सतपथी माइसेल्फ बीए कला शिक्षक, विजय कुमार साहू बीए गणित तथा विज्ञान शिक्षक एवं श्री ललित कुमार मिश्र साहित्याचार्य संस्कृत शिक्षक नियुक्ति दिया जाई अछि। अद्य बैठक रे समानकर नियुक्ति गुडी को सर्वसम्मति क्रमे ग्रहण करागला। मात्र तालीम प्राप्त कला किंबा विज्ञान शिक्षयित्री बिना विद्यालय मंजूरी मिलिबारे बाधा पाई पारे बोली सभा हृदबोध कला। एणु जणे तालीम प्राप्त शिक्षक
Mr. Swain, which are the rules which provide for selection and appointment in unaided institutions?
Your Lordship may kindly see the management
how the rules read.
Management rules of 1991.
Which is the rule concerned?
High school.
How it reads?
Yes, yes. It only says that by the managing committee
after selection.
No, not selection is not there, but as per the government instruction or any other thing. Page 638. Your Lordship may kindly see them.
Are there any rules, guidelines, notifications, circulars which prescribe the private, Mr. G? This question is to you. Whether there are any government orders, circulars, notifications which say memo, which say that these appointment in a private educational institution, that is unaided educational institution,
yes,
should be preceded by a selection process, or they can appoint anybody from the Bakshi market. What's the law?
It will go back. It is a matter recruitment process. What I was asking, it's a matter of 88.
88.
So 91 rule may not.
81. There was a perimetry provision, perimetry rules also. My lord,
earlier.
That was there.
In fact, the school was established in 1988.
Yes.
88. And government has given a recognition in 1990.
1990.
She passed BD certificate in 1994.
Correct.
Petition.
July 94.
My lord. And there is the means of the tribunal is that they have not filed any documents so that they have been duly engaged.
Means what?
And
Means what?
Means there is a process of recruitment. Whether there was an advertisement or not.
Sure,
that should be.
No, that is not contemplated under the rules.
You show that. You show that. No, it is not contemplated.
Yes,
not
but I'm concerned. I'm concerned.
a vegetable vendor from Kೃಷಿ market cannot be a teacher here.
Exactly, my lord. I'm conscious of that. Any appointment is to be preceded by selection process.
Because you are generating the next generation.
Yes, yes. Yes.
The next children. Children are the real wealth of this country.
Yes.
So if you give best education to them, they will be good children.
Yes.
Otherwise, again, they become vegetable vendors.
But so far as the state of Odisha is concerned, and so far as Education Act and the rules framed thereunder are concerned, my lord, here the managing committee, as per the management rules of 1991 and previous rules also, same perimetry provision. The managing committee uses to give appointment by passing a resolution to that effect as per the government instruction or in accordance with the provisions of the Orissa Education Act and the rules framed thereunder.
No,
so far as
I have understood that.
So far as aided institutions are concerned, there is a set of rules.
There is a whole lot of rules.
Set of rules.
But does it mean that the private school, unaided school, can bring anybody as a teacher?
No.
So I want to know. If
your
answer is
kindly see that provision.
What are they?
Your lordship, kindly see the perimetry provision.
No, that will not help you because it's 1991.
91 same perimetry provision is there.
No, early you were appointed
in 88.
No, my lords, that is not correct.
88.
Where is the document?
Resolution I have shown.
Resolution, it is established. She had no qualification to be appointed, my lord.
Which qualification you have prescribed?
Be that is, she passed in 1994 only.
No.
That is the my lord.
Prior to December 1993, there is no necessity of passing B.Ed examination for a trained graduate post.
What was necessary?
Necessity is, as per the rules and as per government instruction also, one untrained graduate can also be appointed against a trained graduate post. So that has been dealt with in a judgment of this Honorable Court, which has been upheld. My lord, may kindly see the 74 rules first, because this has been amended. Your lordship may kindly see. This is unamended rules. Because Rule 5 to 8, 5 to 7 was amended in 1992. My lord, may kindly come to Rule 7C.
To whom these are applicable?
Yes, yes.
Where is the application provisions?
My lord, your lordship may kindly come to Rule 7. Page 11 of that bunch. 7C. The age and qualification is a mistake. The age and qualifications for appointment as teacher and for other posts would be the same as for similar or corresponding post in educational institutions established and maintained by government. This was the rule which
which rule?
7C. 7C. At page 12 of that bunch. Which yes.
It does not have.
Well, that is there.
The age, what is the
age of is a mistake.
Read 7. A candidate for any
selection to which is made by
no. There's one more word you are missing it.
A candidate for
any post.
Any post. Yes, post is correct. Selection which is made by the selection board in pursuance of Rule 6 must fulfill the conditions and be free from disabilities mentioned herein after naming. Then your lordship may skip over.
Come to 6.
C.
7 refers to 7 incorporates 6. Rule 7
yes
incorporate Rule 6.
Rule 6.
Therefore, let us read 6.
Yes, procedure of selection of candidate. My lord, this is for
board shall.
my lord, selection board shall at such intervals as it deems proper call for applications for various posts in respect of which vacancies are likely to arise in the course of the next year in such manner as may be determined in the regulation of the selection board. My lord, this rule is meant for aided institutions. My lord, why I am showing this rule? Because the qualification prescribed for the post of teachers in aided institutions, my lord, is similar to the institutions managed by the state government. Because age and qualification will be the same. Your Lordship may kindly come to see the age and qualifications for appointment as teacher and for other posts would be same as per similar or corresponding post in educational institutions established and maintained by government. But I am giving an extreme example. This is meant for aided institution. This is not applicable for unaided institution. But even an aided institution, my submission is whatever age and qualification is prescribed, my lord, that will be similar or corresponding post in educational institution established and maintained by government. So far as government institutions are concerned, for a trained graduate post, as per government rules, that is 1972, which was governing the field by then I will take your lordship to the judgment. Your lordship may kindly see the 72 rules. This is meant for government employees.
I want to know if these rules are applicable to aided institutions.
Yes.
Can we extend these rules to the unaided?
No, my lord. I am not done that.
No, I want to know.
My lord, my submission before you.
The wrong law.
Qualification. He is speaking of qualification.
That's what. That I wanted.
Yes, yes.
Where it is the number one.
Yes.
Where is the procedure for selection? There must be something.
My lord,
there must be some rule.
but so far as selection procedure is concerned, well, there is no procedure prescribed so far as unaided institutions are concerned.
Your Education Act was enacted in 1969.
1969.
Yeah, there must be rules.
Well, your lordship may kindly see section 10 of the Orissa Education Act. Section 10 of the Orissa Education Act.
One yardstick is there.
And yardstick, I am conscious of that.
Yardstick is there.
Yardstick prescribes the numbers of posts. How many trained graduate teachers are to be appointed?
Right.
How many trained graduate teachers are to be appointed?
If it is there only teachers, then matter will be different. If it is trained graduate, means BA, BEd will be there.
No, not
only
You give that. There must be.
That is available.
Regulations. But not be like that.
Let's kindly have a look to the page.
What is
1089.
Yes. Let me complete then. But here,
You are not assisting me. You are taking me on a particular premise without establishing that premise first.
But so
I am asking, which are the guidelines, which are the rules, which provide for selection of teachers in private educational institutions. A cowboy cannot be appointed as a teacher.
No.
Yes.
So also an oil merchant or a vegetable vendor. There must be some yardstick for this.
But yardstick is there.
Where is that?
That is 8781 yardstick. Your lordship may kindly see.
1089 page.
1089 page.
1089.
Can I place my lord that?
Yes, I have that.
I am directed to say that the question of fixation of standard staff of the non-government secondary school has been felt necessary by the government due to introduction of the revised syllabus under 10 years school pattern. After careful consideration of the various aspects, government had not been
now been
pleased to decide that the standard staff of both teaching and non-teaching for different categories of non-government secondary schools shall be as follows. A, for the school having no additional sections, category of staff. 1, headmaster, public headmistress.
Trained graduates.
Yes.
Graduate 4.
Trained graduate. So there is no question of untrained graduate. one has to qualify B.Ed. Unless he is qualifying B.Ed, he cannot be trained, my lord. He has to.
Whether the word trained, whether the word expression trained graduate is mentioned in any one of the rules? Any of the rules, any of your circulars, notifications, where it is?
It is there.
Which is that? Other the data, his Mr. Slate was appointed.
Trained graduate means graduate with training qualification.
Where is that?
The DED.
Where is that?
Well, this aspect has been dealt with in one of the judgment of this honorable court in the case of Vivekananda Das. Here,
that is different. That is different, sir.
No, exactly same.
That is different, sir.
What was the question?
The question was whether B.Ed qualification is necessary for a teacher. My lord, if he was appointed prior to December 1993, that has been answered.
No, they will read it.
Yes.
The 1974 rules.
74 rules
obviously will be applicable to aided institution.
My lord, my humble submission before your lordships is,
Today, thereafter I shall.
Yes, my lord, if for an aided educational institution, one specific criteria is prescribed, my lord, can a higher criteria be prescribed for an unaided school? I am posing a question to myself.
No, I do not know. You can pose a question to me also, but I will try to answer.
Yes.
The question is, that proposition is too wide and proposition is inferential in Tarka Shastra.
Yes.
That is called inferential question. You cannot infer. Since the sun is hot, all things that resemble sun are also hot. We cannot go that.
No, my lord, I am not doing on that.
I want to hear, but you are not answering my question. That will not help you.
But your lordship,
I am asking a question.
Yes.
What is meant by train the graduate in this, in the light of page 1089?
That is yardstick.
Yes.
But your lordship, may kindly see that judgment.
No, that judgment refers to 1974 rules.
But 1974 rules,
which are applicable to
aided institutions. Aided institution. Your lordship is absolutely correct. But my lord, your lordship, may kindly see, after the school is established, that is an unaided school. It gets recognition from the state government. It gets recognition from the board. Yes, it gets recognition from the board. Thereafter, when the school fulfills the eligibility conditions, it is notified as an aided institution, and the provisions of the aided institution rules are applicable to those institutions. Now, my lord, there is one circular of the state government, your lordship may kindly see, that has been taken note of that in that judgment, para 9.
Para 9 of this judgment.
That judgment. I'm just placing paragraph 8 and paragraph 9.
Untrained teachers should not be entertained in any science.
Yes. That henceforward, untrained teachers should not be entertained in any government high schools. My lord, that is
the government in the said letter being prospective cannot be made with retrospective.
Yes. Which is that now you will see me kindly come to para 11. Para 11 of that judgment. From the foregoing discussions, the following conclusions unhesitatingly emerge. 1. During the relevant time, an untrained graduate teacher was eligible to be appointed as an assistant teacher in a non-government aided high school. He was not eligible to receive trained graduate scale-up pay.
Where is it? No, not like that. Where have they referred to this the circular of 8/7/1981?
My lord,
they have not referred to that at all.
That has been referred. Referred. You will also kindly see paragraph 9.
Para 9.
Para 9. 5.91.
No. 8/7/1981.
8/7/81.
Yes.
8/7/81/86, that has not been referred.
Not referred. Therefore, I am telling you. 8/7/81 was holding the field.
Well, thereafter 91 circular came into force.
That is in respect of aided institution.
Well, it covers all. Your lordship may kindly see.
No, that will not apply to you because you claim to have been appointed in 1988.
1988 prior to recognition.
At 1988,
yes,
the 1981 circular was holding the field.
1988?
Yes. Kindly come to 1089 of the book.
Yes, yes. That circular, that is the yardstick dated 8781.
Yes, 8781 said trained
graduate.
It does not say graduate. The word trained is an adjective.
Yes, yes.
Where do you answer that adjective?
Well, I acquired the qualification in 1994. Subsequently,
yes.
Well, Lordship may permit me to place that concluding paragraph of that judgment.
That will not take you anywhere because that judgment I am holding per incurium because it does. Firstly, I need not go to per incurium also. Firstly, it is confined to the aided institution. For unaided institutions, the norm is established under 1981 circular.
Right, 1981 circular is an yardstick.
Yes, that's an yardstick which acted upon. It was held to public at large. Whoever wants to establish the institutions, if you want recognition, this is our yardstick. If you do not want recognition, you can bring a cowboy and make him to give lessons, class, etc. If you want recognition, these are our terms. There is such a judgment by Apex Court.
My lord.
Therefore, you cannot take me to this. Your argument, what is not prescribed for government teachers itself or aided teachers, can it be prescribed to teachers of the private institute, the unaided institute? Answering, it can be.
So far as this yardstick is concerned, it applies to all types of schools.
I do not know.
You Lordship may kindly see.
This yardstick is subsequent.
No. 91 yardstick is subsequent.
81 yardstick.
81 yardstick is at the relevant time it was there.
It was there.
But this yardstick of 81 has been diluted in 1991.
No, that makes no sense. Even assuming that it is true. Assuming that it is true. You can't argue like that because 81 circular is not brought to the notice of the other court at all. The court was swayed away, saying that there is nothing like this.
No, my lord, when statutory provisions are there, my lord, my submission before your lordship sees, when the statute provides.
Where is that?
My lord, for aided and government schools.
For you, there is no statute.
For aided and government schools, the statute provides that an untrained graduate can also be appointed against a trained graduate post. My lord, that was repealed in the year 1993. Therefore, in this judgment, it has been held that a teacher who has been appointed prior to December 1993.
It went on the principle of prospective effect and retrospective.
Yes.
Nothing else.
Yes.
That question will not arise in your case because the 1981 circular was holding the field. That was not the case. In 1901, Lord Halsbury said in Quinn versus Latham, Lord Halsbury said, a decision is an authority for the proposition that is laid down in a given fact matrix of the case. And not for all that would logically follow from what has been laid down. That's the meaning. What is laid down? What are the facts of the case? What is the proposition? You can't say it is said like that and therefore logically it should be. That is therefore it is said by Justice Oliver Wendell Holmes, law is not logic. The life of law is not logic, but it is experience. You are going logical way. It's very attractive.
Yes.
But logic is not life of law.
Yes.
We do not live by logic. We live by experience. Experience is the government has promulgated a circular.
Yes.
That is holding the field. That you don't have. Therefore, tribunal has rightly said that.
No, tribunal has not dismissed my case.
You do not.
No, tribunal has not dismissed my case on that ground.
No,
tribunal has said
that reasons.
Yes.
But this is if you want that benefit. If the order you are in under which section you have brought it before this court?
24C.
24C.
Yes.
Therefore, it is in the nature of appeal.
Nature of appeal.
Power of the appellate court is coextensive with powers of the court.
Original court. Yes.
Therefore, though the order is made on XYZ reasons,
yes,
you have to show not only order is bad, but order is unsustainable. Order may be bad. That is not sufficient. You have to show, further you have to show, demonstrate the order is unsustainable in law. Now we are asking you, as on that day, These were the governmental norms. Those norms you do not comply with. Therefore, there is nothing in the case.
Well,
otherwise, if I lay down, because it will have horrible consequences.
Well,
it's policy of the state.
Well, here, my lord, admittedly, I have acquired B.Ed qualification in 1994.
July, you have acquired it.
Yes, yes. But the school came into the gratinate fold subsequently. Prior to that, I have already acquired B.Ed qualification.
When did you acquire?
But I acquired in 94, and the school came into the gratinate fold, that is block grant, subsequently.
You show that your appointment,
yes,
it says trained graduate. You were not trained graduate.
That is as per the yardstick.
Yes,
that is as per the yardstick.
Therefore, nothing can be done. There is nothing. Otherwise, I would have done something for your client, because generally I don't deny relief to anybody. This I cannot do, because that judgment I cannot follow, because that judgment is a different scenario. That firstly it related to a particular rule which governed aided institutions. Yours is admittedly not aided.
But subsequently aided.
Subsequently aided because subsequently you are not appointed.
No, I was appointed prior to that.
That as the date you
then my lord, my next submission before your lordship is
when submission I will keep that. The first submission of counsel for the petitioner, that as on the date his client gained entry to the portals of employment as a teacher, there was no prescription of any particular educational qualification in the unaided institutions, and that twice the managing committee having passed resolutions, one on 16/8/1988 and another on 1/12/1988, appointment of his client should be treated as regular is with difficult to countenance. And reasons for this are not far to see. Firstly, there was a government circular dated number 28465 EYS dated 8/7/1981, issued by the Education Department, Education and YS Department, prescribing the qualifications for teachers of the kind for appointment of the teachers of the kind, that is trained graduate. First one. The word trained is an adjective, and that adjective is not satisfied before us, before this court. First, the contention that the requirement is satisfied in July 1994 subsequently, when the appellant acquired B.Ed, would not come to the aid of appellant, come to his aid. First of all, whether appointment is valid or not, ordinarily has to be adjudged as on the date a person gains entry to the employment, and not thereafter what all happens. First, next point. The vehement submission of learned counsel for the appellant.
Well, my another submission is...
No, this I'll take. You contingency or take.
Yes.
That even for persons employed in aided institutions also, there was no requirement of trained graduation, as has been held by a coordinate bench of the division bench of this court in Vivekananda Das versus State of Orissa, 1997, 2 OLR 122, may be correct. So far as aided institutions are concerned, appointment in aided institutions are concerned. First, that judgment is structured on the premise that there was nothing in the extant rules to make them retrospectively operative. First, however, secondly, the said judgment does not adhere to the circular of 8/7/1981. First, therefore, the ratio of the said decision is not invocable in the case at hand, whose fact matrix is miles away from that of the said rule. First, it was Lord Halsbury, who in Twin versus UIMN, Twin versus Ledham, JM, 1901 House of Lords, so and so, said that a decision in an authority for the proposition it lays down, even in a given fact matrix, and not for all that, that would logically follow from what has been so laid down. First off, it was Oliver Wendell Holmes of US Supreme Court, who in Twain versus so and so said, the life of law is not logic, but experience gained through the time spent. First, yes, the next point.
My Lord, my next submission before your Lordship is, my Lord, here the managing committee knowing fully well that
that circular I said, na? Circular, this book.
That is 1089. My Lord, my next submission before your Lordship is,
yes, sir.
Here the managing committee knowing fully well that initially I was an untrained graduate, appointed me as an assistant teacher and allowed me to continue. I am relying upon Bhagwati Prasad case, that is Supreme Court judgment, that
experience itself is
yes, if initial appointment
that was not a case of teacher.
Well, that is not a case of teacher. But if one has continued for a long period of time, he has gained experience, and since he has not got the requisite qualification at the time of his appointment.
The second contention of Mr. Swain,
that is, yes,
that in the light of apex court decision in
Bhagwati
Prasad versus so and so, even if at the entry level a candidate lacked the requisite qualification, that lacuna would be filled up by the long experience, and therefore his client should be treated as having had the requisite qualification is difficult to countenance. First up, the said case did not relate to the teacher. First up, the role of a teacher cannot be undermined. It is they who build the nation. And therefore, only qualified persons can be appointed as teacher, and not anyone lacking it. Anyone lacking it. In Bhagwati Prasad, the case related to regularization of employees, daily rated employees, not in the sector of teaching, but something else. Any other point?
These are the two points.
Yes. Yes. Take this. Okay.
Item 8.
May I please, my lord?
Yeah.
My lord, in this case, the question is the rehabilitation assistance, appointment under rehabilitation assistance scheme. The rule provides that the petitioner needs to be given appointment in accordance with his qualification, your lordship.
Yeah.
The petitioner is a master's degree holder and PG DCA holder, your lordship. Qualified.
Okay, claim higher post. The post in the lowest one, that would be granted as per the policy.
No, as per the policy, it would be according to qualification.
According to qualification.
And Group C and Group D post would be given. And there are 500 plus posts available under groups. My lord, annexure, page number 30, your lordship. Page number, annexure 7, page number 30. The vacancy positions are 450.
No, which entitlement?
My lord,
what is the entitlement?
Entitlement, your lordship, may kindly turn to page number 31, annexure 8.
31.
My lord, annexure 8. My lord, the last provision, that is the RA appointment, can be provided against available Group C, Group D vacancies following the rules, provisions prevailing on the death of the government employee. And that is 1990 rules, your lordship. And 1990 rules makes it very clear, your lordship would see it. Excuse me.
But Apex Court said,
My lord.
The date of, as on the date the application is considered,
Same
rules apply.
Same rule applies. Same rule. Rule 5, your lordship. May I please, my lord?
Rule 5.
My lord. Second page. In deserving cases, a member of the family of the government servant who dies while in service may be appointed to any Group C or D post only by the appointing authority of that deceased government servant, provided he possesses requisite qualifications prescribed for the post in the relevant recruitment rules or instructions of the government without following the procedure prescribed for recruitment. That's the provision, your lordship. It has to be made on the basis of eligibility.
The deceased?
Deceased was a teacher, your lordship, in the teacher, my lord. And there are 500
notice,
my lord.
Requires continuation. Sure, but there's notice like the learned AG is requested to accept notice for AGs. Of this.
Item 10.
May I please, my lord? Well, in this case, the suspension under Annexure 4 has been passed on 7/2025, your lord. The rule provides that it needs to be approved by the director within a month, within a period of 30 days, which has not been done. That would not approve.
Once, if not approved, what is the consequence?
It is to be revoked. That's the consequence, because only for 30 days the management can put somebody in under.
Not beyond.
Not beyond. The proceeding will continue. They have initiated the proceeding, that will continue. That's the limited period.
How the other brother judges have construed this rule?
This rule has been that the managing committee in its current form, it has been construed that they do not have the jurisdiction even to impose suspension.
What is my question?
Well, this question, it is provided in the rules.
No, what is my question?
Your lordship's question was that how this has been dealt with by the lordships of this court.
Yes.
That I do not have right now in such a.
No view on that.
I'll get your lordship given me.
Take notice. Well. He says once approval is not secured, then what is done goes appears to be sensible, because the employee should not be at the whims and fancies of the management. There is some regulatory measure it is.
Exception.
Emergency. Behra accept, learned counsel, learned APA, Behra is requested to accept notice for OPs. In short point is involved. Call this matter the second week of December 22.
Item 31.
Yes. In this petition, the petitioner has approached this honorable court. This petitioner has approached this honorable court. As his name has not been reflected in the main select list, my lord, though he is eligible. My lord? No.
Select list, his name does not figure.
No, my lord.
What is this code?
Though my lord, the petitioner is otherwise eligible and has qualified in the main written examination, my lord. As per their select list, my lord, they have shown the cutoff the mark for at page 147 of the
marks are, what is the cutoff level?
70.25, my lord.
What is your performance?
My performance is 71.25. And
0.25.
And though the petitioner has answered correctly 3 questions, he has not been awarded marks.
Which are those questions?
6, 13 and 19.
What are the questions?
Yes, ma'am. In my booklet, I have annexed that at page 73.
23. Yes. What are the 3 questions and how you answer them? How you understood them?
Yes, ma'am. Question number 6 is a series of situations placed before learners for eliciting specific type of behavior is known as examination, report card, a test, a portfolio. These are the 4 options, my lord. I have
come to questions at page 73.
73, my lord. Question number 6. A series of situations placed before the learners for eliciting specific type of behavior is known as, there are 4 options: examination, a report card, a test, a portfolio.
Where are you reading?
Page 73.
73, there are as many as 13 questions.
73 page, serial number 6 of the questions.
Serial number 6.
Series of situations.
Pedagogy and
for learners for eliciting specific type of behavior is known as examination,
report card, a test, portfolio. And the right answer is examination.
Examination.
Yes, ma'am. I have also answered examination.
But
in the
key answer is there?
Yes, madam. The key answer is at page, madam, 150, madam. 150 is my OMR sheet. I have given 6 option A.
Key answer.
Yes, madam. I am sorry. Yeah, sorry.
Page 85.
88, madam.
Go to 88.
88, where the answer is option C.
Option C.
Yes, ma'am.
Go to C. This
option C, a test.
88. This is the key answer.
Yes, ma'am. In support of my correctness, I have also annexed that answer at page, ma'am.
Take notice. Let us see.
Even if these 3 questions will be excluded,
Still
I am
be higher.
Yeah, ma'am.
That will be 70.20. This 70.20 is the assumption that these three answers are right.
Right, then it will be 75.20.
It exceeds that also. It becomes 70.20 plus
3.75. 3.75.
You accept notice.
Here, my lord, the Abselection Commission, their panel of notice to be.
Issue emergent notice with the Hon'Ble and the requested to accept notice for one technical officers. Learned the panel council Shri is requested to accept notice of the selection.
Sanjeev Shah.
Said Patnaik. Patnaik.
Sanjeev Shah is here.
Let us see. Let us see.
I have filed an IM.
No, I will not halt this one. Any selection or appointment shall be subject to the outcome of shall be list pendants and therefore subject to the outcome of the petition.
Your lordship has already dealt. I have annexed that order. Your lordship, sir. 166 page. Right?
Yes.
No, one post.
This order is made after adverting to the order made by this court in other matters. Okay.
One post we paid for.
Yeah. Call this matter along with WPC 30303 of 2025. Yes, please. Next. Also, number 75. 75. Yes, about 75. Yes.
Whether this is
You are 75.
Whether this petitioner passed the class 12 examination by CBSE board in the year 2024. In the annual examination, chemistry papers he secured 7, and the result came repeat in theory. Again appeared in the supplementary examination. Again the letter came that repeat in theory. Now two chances are gone, my lord. Now third chance I wanted to appear that they are not allowing. That is how.
So the rule third chance is permissible.
Up to 6 years, my lord. The regulations.
Any number of services. Any number of chances.
Up to 6 years.
No.
Up to 6 years.
That means in a year, one chance.
No. Huh? Up to 6 years, succeeding years.
Succeeding year.
Yes. Regulation 43 says.
Not confined to 2.
Not confined to 2. Not confined to 2. Now when I applied for that, the result came out. The computer gives me a result that record not found. Last date was for submitting online application was 11/10, and I filed the application on 13/10. University dealt with this on 15/10, and it took out notice.
This is the first time it has come or after notice?
After notice, special.
Yes, for.
I am appearing for OP number 3.
What is
the school?
School has nothing to do.
School is
it is the board.
Board has to answer. No?
Yes, board.
Who appears for board?
No one has appeared. Just
I'm not asking you. Ordinarily, who represents the board?
I don't know. I can.
CBSE.
Dada Patnaik.
TN Patnaik.
No, I will request him to appear for the board. We'll post this matter day after.
Tomorrow you will see. Day after tomorrow is Saturday. Tomorrow you will see. The examination matter, I will also inform him.
See, fine. So, learned panel council is requested to accept notice for OP number
1 and 2.
180. Petitioner to serve a copy of the petition along with all the documents of the said panel council right now. If solved, post this matter tomorrow.
Tomorrow, may I create the press admission as a press so that it can be taken up.
Let us see, just mention.
Tomorrow I will be liberty be given to mention.
What is my appearance?
See, so appears for. Next.
W 49.
Yes.
Well, this case followed last date. The Land Council for the governing body was directed to produce the records because my allegation was against that opposite Patna for that there was no selection. He has placed some fraudulent document. That is why my friend was directed to produce all the records.
Where is the order?
That order, but I didn't find that order. My lord have dictated. It is not there in the order.
Yeah, it seems it's not there in the order.
Indicated that.
I want to say something, madam.
Yes. No, that has not been typed.
That unfortunately has been typed.
That is not printed. That is it. But he has.
May I be heard for 1 second, madam?
I'll hear you, but I'm explaining.
Direction ticket.
the order which I have made in this matter was wrongly printed in another matter.
Oh, I say
That order we recalled.
here.
Record. That way it happened. There is a direction to you.
Yes.
To produce
Such as some documents such as statement of salary, acquaintance record, etc. But some record they send, but all documents, other documents they have to present today due to their transportation problem in Naxal disturbance. The boss cancelled.
This is Malkangiri. That is not so.
When
maybe
we'll post it on 22nd of December.
I just want to state one point.
Yes.
Your lordship.
Yes.
My lord, this gentleman was the principal in charge. On the given day, the opposite party number 5 was appointed. 1. 2, my lord, he did not have the qualifying marks on the given day that he first offered appointment.
That was when?
That was in 2000, my lord.
All these arguments with due respect is on negative equality. He has gone to the director. That order was challenged before the tribunal. Why he is harping upon my case?
My lord,
He has to establish his
I'm
case.
not asking anything. My lord, I am not saying he is the statutory appeal.
Who?
My lord, therefore, he is in the statutory appeal.
You are,
So,
not me. I have challenged that order in the
tribunal, they have said, but I am only stating that I was selected by due process. I am only stating who he is. I am only stating some things, my lord, which is very relevant. At the given point of time, he was the principal in charge. He gets himself appointed himself in violation of essential violation of Crime Act. He appoints himself. He is the governing body. He appoints himself in 2000. And my lord, that time he has 53%, 53%, which the qualifying mark is 55.
Qualifying marks 55.
Hold the post. Yes. Hold the post. My lord, thereafter, my lord, what he does, some few years back, I think 7 years later, my lord, he take in between, in an interregnum, he takes another examination in Orissa, same subject, my lord, from another university. And he gets a marks which is above. My lord, number 1 is that you are prohibited to take the same subject examination a second time at all, my lord.
Not permitted.
Cannot.
In other university also.
Any other university, you have to disclose that I have taken Orissa MA in this state, that for this marks, my lord. Otherwise, my lord, someone go on improving the 10th time and come and say that I'm qualified, my lord.
No.
My lord, there's a bar.
No. But this bar is that you cannot put it into
use.
But I will get.
Yes, I know. But that is possible. Yes, that is possible.
Yeah. But you cannot put
utilize it for that.
Utilize for service.
Yeah, that's my short point, my lord, here. 2, my lord, what happens, my lord, he has to.
My lord, with due respect to my senior, what I have to say, what he is arguing, what is the case? First of all, I am the petitioner.
I am saying.
He is arguing entirely, which is not on record. What was the challenge?
My lord, the record.
That is why my lord have directed to produce all the record. After hearing 2 lines from me, these are the submission made.
I'll hear you also. The learned senior advocate wants to say something.
That's the problem.
My lord,
just so that I can record it next time.
Yes.
I will not argue the same thing again. I leave it to your wisdom. If you argue all this now,
yes, ma'am,
that is stored in my brain, subsequently I will not permit you to repeat it in my court.
No, very good, my lord.
Yes.
Very good, my lord. I want to indicate that much, my lord. I don't have to. I'll give a note also. I've made a note, my lord, which I.
Because when case comes, if you argue, that will be helpful to him also. That may be advantageous to you also.
Yes.
But again and again, I will not hear.
No, my lord should not hear it.
Yeah.
No, my lord should not hear it. No. I also don't want my lord to not to hear it piecemeal. I don't want it.
But
if my lord
that
wants,
is the point. And so 22nd.
yes. I have no problem, my lord. I have no problem.
How many days? Monday. This is FA. Therefore, 18th inch. 18th inch on Thursday.
Yes.
Will it be convenient to you? Perhaps it appears, sir, travels from some other place.
I'm not very well. It doesn't matter. I'll be available before my lords anytime my lord carries. I'm doing it.
18th.
Yes.
Well,
Item 50.
My lord's item 50. Maybe taken any other day.
But item 50, I'm appearing for the referral number 1. But I'm not objecting. Only thing I pay a short date because I've been denied the block grant since 2008, my lord.
50. Put it on the 24th
of November?
November, not possible. Many matters.
December?
Yeah.
But December, then in that case, your lordship may fix it to first week of January.
Call in the first week of. Call immediately after reopening of the court. Court. After winter vacation. Winter vacation is there for you?
Winter vacation.
Wait for me.
Item 51.
Your Lordship, I'm appearing for the appellants on behalf of Mr. Rautrai. I pray for an adjournment.
You pray for adjournment. All right. Second week of January 26.
Much obliged.
At the request of.
Item 52.
Yes. Yeah. Yes, sir.
But the short question
is for the other side, whether ready.
State.
After hearing, you should not say, I want time, because that will be wasting the court's time. If you are ready, yes, I'll hear you. If you are not ready, I'll give accommodation if you want.
Okay.
Ready.
This is a case where the petitioner, where the appellant was initially appointed as a demonstrator in physics.
Very fine.
But may I suggest one thing?
Yeah.
Date chart is necessary.
Date chart to be filed. In the first
So for the factual aspect, you can 2 to 3 points are there.
Yes, yes.
For that date chart is.
Very
date chart is necessary.
Date chart. To facilitate filing of date chart by the parents. Next.
Item 53.
53, my lord. Yes.
In 53, in the second case, in the first case.
Connect Mace.
Yes, yes. I am appearing for the
3 cases connected out of one judgment of the tribunal. The issue is very simple. If I am selling with my friend because he is for the same client, I'm saying. In 2 appeals, I was in one case, he was in another case. The issue, if my lord permit me, in 2 to 3 lines, I can only submit also, subject to.
Date chart is not necessary.
Not matter. But this only very few points only. Only point of law, my lord. What happened,
Mr. Monty, are you ready in the matter?
Yes.
Yes.
Only point, my lord. Yeah. My lord senior will place if he wants more. Only thing, my lord. In a Sanskrit institution. Yes, in a Sanskrit college, there is only one subject that or normal subject is permissible to be taught. That is either political science, history, or any other subject other than Sanskrit. That is the yardstick they have published. So, my client, the Sarveswar Lenka, was appointed as a lecturer in history. List of date. My client was appointed on 8/9/96, joined on 29/96. That date is there, my lord.
What is the point in what?
Point, yes, that is my lord. I am just placing. But my lord may not write anything, just I am kindly 2 to 3 lines only, not more. My client was appointed as a lecturer in history. My lord senior's client.
Need for writing anything?
Nothing, my lord. It is there. Just I am point of law I will place, thereafter they will argue. So, the other, my learned senior's client was a lecturer in history. He claimed that I was a lecturer in political science.
Your client is
history, lecturer in history. My appointment was in 96. His appointment in 94.
Yes.
So he's ahead of me. So then if he comes first, then he is to get the benefit. I should not, because one post is admissible. My appointment.
Only one post.
Yes, only one post is eligible for granted and all this thing. But the dispute actually starts when my client had the qualification that minimum MA. I have secured 416 out of 800. That sometimes 52 point some odd percentage is the requirement. I had. But inadvertently, it goes on record to the authorities. It is 446. One become 4. That 446. But I do admit 416 is the mark. There is no dispute over that. I had the. But my learned senior's client, the other person, he didn't pass the MA examination in 1994. He didn't have the qualification.
As on the date he was appointed.
Appointed 94. He obtained in sometime in 95, 96. Much after. So therefore, my appointment was approved. He challenged that. So now the question comes before, this was earlier occasion before this Hon'Ble Court also in another affair. So the only issue comes for whether my appointment is valid or his appointment is valid. Now the question comes, their argument was, since I have 52 point some odd mark, I should not have been appointed because the requirement is 54% mark. That is also the finding of the tribunal. But his has no mark, so therefore the tribunal says he is not eligible to be appointed. But so far my claim is concerned, well, 52% is the eligible mark. What the tribunal has committed the mistake is by referring to a circular of 1987, fixing an appointment of a lecturer with 54 marks, 54% of mark in post-graduation to be appointed as a lecturer. But that has been nullified because the Sanskrit institution, where at the relevant time was under a separate circular.
The circular is dated what?
87. That is 11.
That is before your appointment.
Yes, 87. But before my appointment in 31/12/1992, the state government has brought in another circular and saying that all these Sanskrit institutions, this +2 is called Upasastri, Sastri is called the +3. These become equivalent to the general qualifications and general institutions. And the statutory, that was a circular in 31/92. In 94, the act is also amended accordingly, Odisha Education Act. And these institutions were at par with the normal colleges. So therefore, all the provisions of the Odisha Education Act and rules from thereunder made applicable to the Sanskrit institution, and thereby, yes, no, yes, sorry, no, it is because that is only one sentence. But thereby, one the provision of law is been made applicable to Sanskrit institution in 1990.
Retrospective? Is it with retrospective?
No, from 94 even. Mine from 96.
You were appointed in
96. Much after that, 94 Amendment Act. So after the Odisha Education Act made applicable to the Sanskrit institutions, there is a rule. The management to the appointment of teachers, there is a statutory rule, and that says for appointment in a Upasastri or +2 college, the qualification is 48% in post-graduation, not 54, 55.
Which we had.
I had, because I have 52%. So that is why my case. But the tribunal has proceeded as if that 87 surplus still holds the field. That is the only dispute.
Rule position is not looked into.
We have produced it. He says no, this rule has no application. But the statute says
rule is not applicable.
That is
no, according to
no, it is applicable. My case is it is applicable because the rule says so.
Rule is of which year?
94 Amendment Act.
94 Amendment.
Yes.
Act itself is amended.
Yes.
Making it applicable to
Sanskrit institution, making applicable
Shastri and
Upasastri. Shastri is +2.
Shastri and Upasastri.
Shastri is +3. Upasastri is +2. And Madhyama is high school. Then Prathama is elementary. That is this is the actually law and fact involved in this case. That is the only case.
What is your case?
The same as I am selling.
We are sailing in the same boat. My lord, my only submission before your lordship is, in addition to his submission.
Now,
my lord,
I have another matter. That is why I have requested my senior to continue. I have another matter in another court. Shall I take leave, man?
Yeah, no problem.
This is the issue.
Only thing is you have to share the fees now with your friends.
No,
Yes. What was your percentage?
Same
client, madam.
More than 52%. 52%.
Two cases I am one. My senior is one.
52%.
No. You did not have the qualification at all.
My lord, kindly allow me to submit from. My lord, actually, this appeal relates to an institution which is based on the Hon'Ble of Sanskrit. Sanskrit symbolizes civilization, the culture, from Vedic age to discourses of Shankaracharya, my lord. But today,
before Shankaracharya,
but today, this term, Sanskrit, has been used only for polluting the education and polluting the system. It has become the paradise from some parasites, my lords.
Because Adi Shankara, in two works, one is Viveka Chudamani.
Yes.
Another is Moha Mudgara.
Vivek Chudamani by
Shankaracharya, Adi Shankaracharya. That state is very nearby Bangalore.
Yes, yes.
Kalati.
Kalati.
He has referred to many other Sanskrit texts before he did something. It is not that Sanskrit took birth when Adi Shankara took birth in the 7th century.
Yes.
In 7th century or 8th century, some dispute about that. He refers to Kumarila Bhatta.
Yes, it's a Buddhist scholar.
Yes, Buddhist scholar. Therefore, Sanskrit did not take birth along with Shankaracharya. It was there long.
Yes, I say from pre-Vedic age to Shankaracharya, my lord. But the thing is, today, that particular one is used and has become a citadel of corruption and of education. And so it has become a paradise of parasites, my lord.
My question is, what was your qualification as on the date you gained entry to the portals of employment?
My lord, I admit I have no requisite qualification at the time of recruitment, my lord. But as I am a local candidate, a native man, I had appeared in the final year post-graduation exam. On conditional basis that they gave me appointment. May I admit, I had no requisite qualification. But at the same time, my lord, they had also no requisite qualification.
Why do you say?
They had committed fraud. It has been verified. It has been come to a conclusion by 3 courts. 2 orders of the tribunal and the High Court also. They have produced false mark sheets.
Give them.
Said 52% is also false, my lord.
Give them. Rhetoric is one thing, evidence is another. Wherein it has been.
My lord, it was produced by the university before the High Court. I can give you the judgment. Kindly go through a judgment.
Give.
That judgment was set aside.
That is set aside?
Yes. Judgment of the learned tribunal was set aside and the matter was remitted back
on this
to the tribunal again.
The mark was called for from the university and university produced this certificate.
Because
that was 416 was my mark.
The RTI
the High Court remitted only on the ground that when High Court became confirmed that mark is fraud. Seal cover, it was produced before the High Court and it was verified that he has submitted a fake mark sheet. That is why matter was remitted back. And the tribunal, after hearing both the cases and has dismissed my case as well as their case also. But unfortunately, they have taken the interim order. Their approval order has been quashed. Still then they have taken interim order, my lord. That's the thing problem.
Well, on the basis of RTI information, these sets of marks were given. And in order to ascertain the correct mark sheet, this Honorable Court directed this Council for the University to produce the mark sheet, mark foil. And accordingly, mark foil was produced.
It is the order of the High Court when the remanding was made.
Whether High Court has recorded a finding as to fraud and fabrication?
No.
Read that paragraph.
No.
Read that paragraph.
That is the only copy I have seen.
My lord, kindly say. That judgment I have given.
Give him this judgment.
It is there. This is
Rather, he has committed fraud.
We have. This is the judgment of the
I have
High
not
Court.
committed fraud. I have no qualification. I admit that.
Let us see. You say that they have. If you have qualification, you have to yield the place is one thing. We should occupy that place is another. We'll come to that one now. Now show that the court has recorded that they are guilty of other fraud fabrication.
201.
In FAO number 470 of 24, where I have filed, I have annexed that judgment of the Honorable Single Judge. Honorable.
Show it to your brother.
Yes, that paragraph 6. Finally, see paragraph 6 of that judgment, madam.
6 option.
To submit.
Let him choose. Let him. Yes, paragraph. Let him choose the paragraph.
Paragraph 6.
Paragraph which he wants to show. You want this one? It becomes easy for him. Yes. Yes. So,
That is on record, my lord, maybe. Page 55, next page.
In the first case, I have given it page 201.
yes, sir. Show the findings. Why can't you mark a yellow pen? You should mark which you want to highlight to the court. That is the only point you have argued. And you are searching for that. What kind of advocacy? All facts should be on tips. Now we'll read from the cast title to the end of signature part of the judge.
No, I was showing.
So many times I was requested.
My lord, para 7, my lord, I'm reading. This court, considering the submissions made by the London Council appearing for respondent number 5, when directed the university to produce the marks secured by the appellant in his MA examination, London Council appearing for the university produced the mark sheet of the appellant in a sealed cover. This court, after going through the same, finds that the appellant in fact has secured 416 marks in his MA examination held in the year 1996. But it is found that the tribunal, on the ground that the appellant since produced a fake mark sheet by showing his marks as 446, got the benefit of appointment. Accordingly, was not inclined to interfere with the direction issued by OP number 2 in his order dated 3/6/2016. The tribunal also held the appellant not to have the required percentages of marks in his MA examination for his appointment as lecturer in the history.
No, where is the finding? It's a contention.
It's a contention.
Similarly,
clear by para 8 now. Read. Similarly,
London Council appearing for the respondent court contended that.
Similarly, he also contended. That means now what you have read was contended. This is another contention.
Finally,
where is the finding?
That at the relevant point of time, taking into account the workload, lecturer in political science was also admissible, and accordingly, tribunal allowed his claim. But London Council appearing for the appellant contended that as per the workload prevailing at the time of appointment of respondent number 4, post of lecturer in political science was not admissible. It is also contended by the London Council.
Leave the contention. You will contend everything, that sun has merged with moon, moon has merged with star, etc. And what are the findings of the court?
Finally remanded back.
Where is the finding that they have committed fraud, fabrication, duplicity?
So when it was produced in the sealed cover, it was
what is produced?
The court came to a conclusion that is why it was remanded.
Where is the conclusion? If the conclusion was there, where is the question of remand? If conclusion is there, that they have committed the sin of
because of the factual complexity, because of the factual disparity, that's why the matter was remanded back to the tribunal.
Therefore, there was no finding.
There was no clear finding that it has committed. But as per the seal cover mark sheet, it was found that mark has been fabricated, what mark sheet has been given. That is why.
That is the contention.
I know.
But that contention is considered for being considered by the tribunal.
No, that tribunal has considered.
Therefore, there is no consideration. But there is no finding.
No, that is
you say
by the tribunal, it was thoroughly verified and it was found there in the tribunal order. That is
put in challenge now.
Like
the tribunal order is put in challenge here.
Yes, that is challenge, my lord.
That is their challenge now.
That is one thing, that is a first mark sheet. Another thing,
first thing I am not convinced.
My lord.
First thing, that there is fraud, fabrication, duplicity by the other side. That finding is absent.
My lord, when the mark sheet was directed,
We're only repeating the things. I can't help. I cannot go on repeating. I can understand only in one sentence with the experience I have. But that finding is not there. Then what are the which other matter? You admit that your client did not have qualification at all.
I admit, I had no requisite qualification at the time of appointment. That I passed my examination in 1996 and produced all my documents before the legal concurrence or permission of the institution has been done. This is the thing I admit that.
Learned counsel appearing on OP respondent number? Which respondent?
I am appellant in the first
case is the appellant.
I am the appellant.
In your case, which respondent?
Is the respondent number 5.
Respondent number 5. In your case, which
Even she has not been made a party.
in the direct number 5 in Mr. Swain's FAO. What is it? 468. Who happens to be the appellant in the companion FAO
470
of 2024. Very fairly and more than once admitted that his client, going by the normative basis, did not possess the requisite educational qualification. First, however, he submits that that his opponents have perpetrated fraud and fabrication, as has been recorded by a coordinate bench of this court in WP in can you see that?
FAO number 816 and 817 of 2018.
Disposed of on order date.
Order dated 6 to 2020.
6 to 2020. 24. First. Having turned the pages of the judgment, he is not in a position to show the finding as to fraud and fabrication. First one. There cannot be one. Obviously, because had there been one, the matter would not have been remanded to the tribunal for fresh consideration. First one. Therefore, the contention of fraud fabrication attributed to Mr. Swain's client, who also happens to be client of Mr. Das, falls to the ground. Next point. Learned counsel appearing for the counsel, Mr. Das and Mr. Swain, respectively appearing. Das appears in what?
470.
FAO 470.
Yes.
470 of 2024. And
Mine is
Mr. Swain appearing for
468.
same party in
460.
FAO 468.
Yes. 468.
468 of 2024.
Yes.
Submit that their client had a percentage of 52,
around 52%.
Around 52%.
Total 52%.
In MA history. MA history. And therefore, the requisite being
48%. As per the provisions of Odisha amended.
No, man. That is 54%.
48% under the Amendment Act, which
this is the rule, my lord. Odisha Education Service within bracket higher secondary branch method of recruitment and conditions of service rules 1991. That was made applicable from this Sanskrit institutions also. 48%.
Which are applicable to Sanskrit institution.
In view of section.
View of amendment to section 3.
That explanation is first
Of
3S.
3S.
Explanation to 3 small s.
3 small s of Orissa Education Act 1969.
69.
And
that is section capital 7C, 7 capital C of this Odisha Education Act.
read with section 7C.
7C5.
7C5. 7C5. That means once it becomes a general institution, then provision of the other provisions, normal provisions will apply where it is 48%.
Yes, that is our.
What do you say about that?
My lord, there is a special provision in the code for Satri Upasatri colleges. And on the basis of this order, my lord, they have got granted of 2000. As for that provision, my lord, 54% is mandatory. This is my lord.
Mr. Government, what do you say?
Yes.
With whom you are standing?
No, my lord. So far the tribunal order is concerned, very meticulously they have clubbed up 2 issues and passed this order, my lord, which is the impugned order before my lords. So far 2 dates is
common order.
Yes, common order. 2 dates are concerned, my lord. One is of 28/1994.
Amendment.
No,
92 is amendment.
92 is amendment. Before that,
That's their
94 one appointment is there.
96.
So far, the Mr. Das client is concerned.
96 amendment.
So, Kanu Naik, the 2 persons are there. One is of Kanu Naik, another is of Sarveswar. These are in item, sub-item and the next item. Kanu Naik is the first client of my learned friend. Kanu Naik appointed on 8/9/1994.
8/9/94.
This is so far Mr. Das client is concerned. Sarveswar is concerned, appointed in year 1996.
Correct.
It is in 8/9/94.
But he was appointed have qualification.
But appointed by virtue of the GB. Later on I am coming, my lord.
Okay.
8/9/96, same date, but only the year is different, 94 and 96. Later on it is found, so far the 96 appointment is concerned, they are making for so far the marks is concerned. That has been all taken care of and annexed as I and J before the tribunal. That has been all taken. So far 94 appointment is concerned, which continuing much prior to Mr. Das client.
No, he has not passed out.
Later on, it is found that he has not completed even MA during the course of service. He has completed the master
MA
degree.
in 96.
96.
Which date? After your appointment or before?
May 96.
Before. Before you were
May 96 is before appointment of Das.
Yes.
Yes.
Because he is in 8/9, he is in May 96, it is in 8/9/1996. And so on the ground of for submission of the mark sheet, so far this MA part is concerned in 96 appointment, and so far the 94 appointment is concerned having no requisite qualification. One is of lack of qualification, another is of lack of percentage, as it was required in 54%.
No, they are saying.
No, later, by the time it was 54%. So far the master degree is concerned, they are having 52 point some order, 51.
No, it cannot be 54 because 1992 amendment, which they say, section 3, reads it 7C5.
That is not applicable to Sanskrit colleges, my lord. That is a special provision, my lord. 54% is mandatory in the general subject. There is no condemnation provision or nothing to condone that or to exempt that.
Yes.
Nothing. That rule is not applicable to Sanskrit colleges.
Yes, that rule is applicable. Your Lordship, kindly see
Any judgment on this point?
No. And 3 marks they have submitted.
The 3% husband
is so far the forge is concerned, mark sheet is concerned. One is of 416,375, then later it was 446 out of 800.
Why 3 marks section, 3 marks cards?
Because they have some
That's known.
No. That is in annexure
3 marks cards.
I, G and H. It has been taken care of in the judgment itself.
Information obtained by him.
Yes,
3 sets of marks were given.
Procured under the
And in order to ascertain the truth, this honorable court directed the counsel for the university to produce the mark file of
And
the.
they produced it.
They produced it and it was found 52%.
No, 3 marks cards.
He is only. RTA.
Under the RTA.
He has obtained RTA information.
Where from? Yes,
And that
produced.
point is gone because of the decision of this honorable court.
Then High Court directed to produce the mark sheet to the university. That is the most authentic thing. What is there in the seal cover? Sir, my lord, kindly see these 2 letters of the government. They have asked to take initiate proceeding against that person and to withhold the granting. Sir, kindly see the 2 letters of the government.
Subject matter of challenge in the tribunal.
That was challenged. In the
In this
second
case.
case, it was challenged.
And
In my case.
54% cannot be condoned.
No.
On the basis of this order, they are taking the granting aid. How they will claim exemption from that order now, my lord?
What my learned senior is saying, just may
There's
submit it in 2
54%
lines.
is mandatory.
Sir, yes, sir, what the rule 91, what I have referred to, that 48% was there. That was for the higher secondary schools. That means +2 colleges. Like Upasastri became a higher secondary schools in
By virtue of
a government notification.
which notification?
That is a circular 31/12/1992 first initially and section 3S.
Yes, explanation.
7C5.
And 7C5.
7C5.
So it was in 1994.
Yes.
Yes.
3 years. You have to see the explanation.
Page-
That was
Page
the
170.
order made up in 1987. They are also same provision there.
Ticket work.
87 also there is the same rate. 54% is demanded.
Lordship, may kindly
Again,
see
that has been
page
written in the 2008 order, my lord. There is no condemnation.
My lord, may kindly see page 117.
170.
No.
117.
117.
That explanation appended to section 3S, definition chapter. An educational institution imparting Shastri, Upashastri, Madhyama and Prathama courses of Sri Jagannath Sanskrit University shall be deemed to be a college, a higher secondary school, junior college, a high school and an upper primary school respectively for the purposes of this act.
This is effective from
Act 13 of
1994. And thereafter,
before your appointment.
Yes.
14/7/94, the amendment has
and
come.
thereafter, your lordship may kindly see section 7C5.
One second. Section
7 capital C.
3, yes. As amended by Odisha Act number 15 of 1994. Whatever it means. Main yes explanation. No. Explanation to section C, yes,
Small s.
small s. As added by Odisha Act number 13 of 1994, the educational institution imparting Shastri and Upashastri came to be deemed to be a college and a higher secondary school. Higher secondary may not be applicable to
college.
Yes, college. College. Stroke junior college.
Yes.
Once it becomes a junior college, what is the effect? Go to 7?
7C. 138 page, madam. With regard to this 7C, it deals with grantinate. Section 7C, 137 page. 7C. This deals with grantinate. 5, madam.
7C, 5.
5C. Sorry.
Oh, C.
C.
Page 138.
5C.
5C.
Higher secondary school or junior college imparting instructions or courses, higher secondary examination conducted by the Council of Higher Secondary Education Odisha, or institution imparting Upasastri course of Sri Jagannath University of Madrasa imparting equivalent course. So that the institution eligible to receive the gratuity.
It is not under Sri Jagannath University, my lord. It is under our state government education department.
No, probably you are not correct. Only Sri Jagannath Sanskrit University.
My lord, if that rule of 1994 is applicable, then why this order in 2009? Why this provision? Why is it not amended?
So there are
1994 will be applicable.
Upashastri course.
Yes.
In Sri Jagannath Sanskrit University.
Yes. Yes.
You are not from that.
No, all Sanskrit institutions of the state are affiliated to only one Sanskrit university.
That is Jagannath Sanskrit University.
Sri Jagannath Sanskrit University, Puri. Only now Madhyama has been taken out.
Yes.
It has been under the Board of Secondary Education, Odisha.
And so far as Upasastri and Sanskrit is concerned,
still under
that is under the Jagannath Sanskrit University.
What do you say, Mr. to this in response to this argument?
That is my lord.
That is true. Mr. Swain and Doss, well, draw attention of the court to section 7C capital. It's into bracket 5, another bracket small b, to contain that
C.
The
C,
not B. C.
Higher secondary school.
The junior colleges imparting
instruction.
Upashastri.
Yes.
Upashastri.
Shastri is not there.
Shastri just D. D is for Shastri. 4 category for institution. Elementary.
College. So yours is Upashastri.
Yeah, this is Upashastri.
No, both the streams are there. Upashastri and Shastri.
Yes,
in this
Upashastri course. Also will be entitled to the grant in aid.
Yes.
And that all institutions conducting the Upashastri course in the state are affiliated to Sri Jagannath Sanskrit University First up, Mr. Mohanty, learned AGA being specifically questioned, agrees with this position.
And what my learned senior was trying to impress upon by referring to that granted order, which is an order under the statute. Where it is said that, kindly see, my lord, that is at page 442. That he's saying this referred to 54%. That is in 2009. My appointment is prior to that. So I will not
page
go on.
138.
And then 440, sorry.
And page
440.
117. 440.
440.
That is Odisha non-government Upashastri and Shastri granted order 2009. This was brought into the statute book by exercise power under subsection 4 of section 7C.
This is a subordinate delegated legislation.
This is in 2009, my lord. Much after.
Much prior.
Much after my appointment. So my
appointment was in 1996
as per the act. So this was not there. So what is referred to is, kindly see, my lord, there is a yardstick there. They have given an annexure.
In page 442.
Page 442. In the note. Last note. Qualification of lecturer. 442. Towards bottom, last
serial 3.
Serial 3. Qualification of lecturer to Upashastri, Acharya, Acharya and MA. 54% and above mark in the aggregate. That is in 2009 only. This has come 28th February 2009.
2009.
That is long after your
my appointment.
28th February 2009.
This could not have any operation on me. That is my
no, which said 48%.
48%, that was
91.
That is, my lord, in the general rule, my lord. In the 1987, there is a committee order regarding to Shastri Upashastri. There is 54%. My lord, they are confusing. Where there is Shastri and Upashastri,
Slowly. Softly. Keep your emotion at the back seat.
126.
This is war of intellectuals. Advocacy. War of intellect.
for that.
Not war of emotions.
Your Lordship may kindly come to page 382. Of my brief.
One second. He wants to say something. See, now because of this rule, tribunal is saying that you lacked.
Yes.
That is the problem.
And also referring to that 87. So initially it was.
Council also draw attention to Orissa Education Service. It's all one furlong.
It is higher secondary branch, method of recruitment and conditions of service rules.
431. Relevant page 442. Which prescribes
87 or 54?
Which prescribe 54% in the relevant subject as the requirement for appointment. And that the appellant having been appointed way back in the year 1996. These rules were not even in pipeline. First, the apex court in the case of decisions has held the requisite qualification should be adjudged as on the date the selection stroke appointment took place and not on the basis of the rules that come into force subsequently. First, where is that 48%?
Your Lordship may kindly see my brief, page 382.
Extract, please.
That rule is not applicable to Sanskrit college.
Let us complete.
There is a specific rule in 1987 regarding to Shastri Upashastri. I will show that.
I'll come. This is their contention. I'm just recording the contention.
In my brief, I have given. That is page 382.
4D.
4.2D.
4.
What is this?
This is the qualification prescribed by the government in that particular rule. 4D. Next page.
General college.
Next page. 4D.
Next. They also draw attention of the court to 1991 rules. Promulgated under these rules are made under which section?
This is under section 27 of the rule making power of the
rule making power.
Under section 27 of the 1969 Act. Very Rule 4 under chapter 2, Roman 2.
Small d.
Small d. Rule 4, small d. After chapter 2. Prescribes 48% of marks or its equivalent grade in the master's degree in the concerned subject.
This is undergone an amendment on 10/11/97 when it became 55% again.
That I have given at page 390 of my brief. 11/6/97, it has undergone an amendment.
This rule is amended with effect from
11/6/97.
11/6/1997. Altering the requirement to 55%, which the petitioners did not have. First off, however, they submit that petitioners having been appointed way back in 1996.
That is
the requirement was 48% under the 1991 rules. And therefore, what is altered would not be applicable to them. First of all, this aspect, according to them, has not been adverted to by the tribunals. And therefore, the order suffers from error apparent on the face of the record. Sir, you were saying these rules are not applicable.
Not applicable. My lord, in 1987, there is a order for a Shastri Upashastri. I'm presently not to that 19 youth and the education department. They have got annexed in their.
What do you say about legal
so far this 87 is concerned, admittedly it was 54%. Then subsequently by virtue of amendment, then it reduced to 48%. Then
considering the case of
no, that is not for Sanskrit college, my lord.
He is saying that. I'll come to that point. Wait.
But so far this latter on stage in 97, then it.
You are saying what I have dictated.
Exactly. But here, my lord.
This position.
No, my lord, that is the position.
Mr. Bhakti being asked, very fairly admits this is the legal position.
But it is not understood before the tribunal why the person concerned has submitted 3 mark sheets, which is declared to be forged one, not approached the tribunal in clean hands.
He has produced. He produced it.
Yes, my lord. Under the RT Act, my lord.
He produced what they should do.
Well, under the RT Act, and later on it has found that the mark is 446, my lord.
416.
416.
That is 52%.
It's more than 48%.
But the 3 mark sheets are there under the RT Act.
That was produced by them.
Not produced.
That has been old.
Somebody applied for mark sheet. Somebody obtained it. And somebody produced it before the tribe.
So taking into consideration.
They produced.
Yes.
That you should have asked the university. No, a dozen mark cards are produced before us. Which is the genuine one? Which is not the genuine one?
So
that you should have put.
They produced the mark 446. Now they say it is 416.
No, the honorable.
They have produced 446. Is it correct? Is it correct? Is it correct? They have produced it. Now they say it is 48%. So we have 416. That can be managed.
That is the control of examination. Utkala University has submitted in the seal cover.
Seal cover.
Which has been marked as G by 5 and H by 5, which is 446 out of 800 marks.
416.
Even if it is 416, it is more than 48%.
That rule is not applicable to Sanskrit college, my lord. I will have the argument. My lord, in 1987 order,
sir, I will.
Shastri, Upashastri, there is must be 54%.
Yes.
My lord, they became eligible to get granted in 2011.
No.
And this order is of 2009. Again, that provision has been repeated. That mandatory percentage of marks is required, 54%. Why?
Where is your junior?
My lord, this is not point of appointment. This is not question of.
Where is your junior colleague to control you?
Right?
You should bring someone to control you.
Yes, my lord.
Now I am asking you with due respect. You are saying 87 rule governs the issue. Circular. You that circular.
There was no specific law regarding this Sanskrit college. So circulars for time to time there is governing this issue. So 1987 circular says.
Show it, sir.
Sir, that is, I have not a copy. That is annexed to his FO.
Read that.
That is annexed to his FO.
Yes, so please share your papers with sir.
38, page
yes.
30.
Move page 39. This one. You want to say? This
38.
No, I move 39 page. It is a good one. 15, 10, 87. The question of 854.
Minor page 40, minor.
45.
40. Page 40.
4705. 470.
In my case, page 30.
No, page
38 is beautiful. This was a
page
was a book
Page 38. In my case, page 38.
39. 39.
In my brief, that is page 38.
15, 10, 87. What it says? My lord, it says that this is a letter of the Government Education and Youth Service Department to the directors. Staffing pattern of Shastri and Upashastri Sanskrit institution. I am directed to say that
After careful consideration, government have been pleased to prescribe the following staffing pattern for the Sanskrit institution having Upasastri and Sastri course in the state with a minimum student strength of 32. Now, staffing pattern.
That is
staffing pattern.
pattern.
Yes, that was what last next page. Qualification of lecturers at Upasastri and Sastri stages will be as per the government yardstick, that is Acharya, New or MA in relevant subjects with 54% and above mark in the aggregate. This was 87. What our case is, after we brought into the Odisha purview of the Odisha Education Act.
Yes.
This 91 rule, this came into play.
Yes.
So 91 rule will override this circular.
My lord, 91 rule is not applicable. I will justify. Kindly give me another date. I will justify. That rule is not applicable. If that rule is applicable, why this provision is there in 2009, my lord, regarding Sastri, Upasastri? And they are getting granting under this provision, and they will take granting and they not qualify the qualification, requisite qualification. It is anomalous, my lord.
Sir, I have spent more than 1 hour on this case. If you ask time, how I should remember, how they should remember, how much time I should spend on this.
That is more to be introspected in the my lord. That's rule not applicable. I am sure.
No,
that rule is applicable to Sanskrit institutions.
No.
But that's confusing. This rule is, this is the valid rule, my lord, provision, this order. Under this order, they have taken granting it. That is where the tribunal has rightly plus their approval order, his approval order.
No, you want time for what purpose?
I will justify that.
You have given you.
I am not going. I have not gone through that rules. I will just verify. They are talking of 1991.
No, that is pleaded.
Kindly give me a date.
Before the tribunal, before the submission, that rule was there.
That rule is not applicable. I am sure, my lord.
Your submission.
They are confusing. That rule is not applicable. This is the final provision to get granted for Sanskrit colleges.
Just give the submissions.
My friend is also not sure, I think, regarding that rule. He is admitting that he is not sure.
Huh?
That rule is not applicable.
When do you want?
You need it next week.
How much time we have to waste on these matters?
My lord, this is a way of submission. Time is not found by me. Once I so it is.
These things. In our make the rule
wanted to continue.
We don't see the against for the 10% submit test. These aspects having not been appreciated in the right perspective by the tribunal, the impugned order is liable to be set aside. And their appeals are entitled to be allowed. First, at this stage, learned counsel appearing for the opposing party, who also happens to be appellant in one of the companion appeals, seeks some time to make research and come back. First, call this matter on 20th. Sir, that day you come with your note and take assistance of a junior also. That helps you. That helps everybody.
Interim order to continue.
Interim order is continued.
In the first case, I have appeared.
In the first case, only one. Same thing.
In his case, I have entered appearance and filed vakalat.
We are wasting a lot of time. Therefore, matters are pending. Yes.
54.
Yeah, please, you have the very limited question.
Yeah.
Only the lords will interpret the statute. And if the interpretation made by the learned tribunal is valid, then I have no case. If whatever I am interpreting, your lords will accept me, then I have 100% case. So for the facts, nothing disputes. Only I am placing the facts for 2 minutes, then I will go to the particular laws.
Do you have a date chart with you?
No dead chart in there.
This is first
Date chart will help us.
No, can I have 2 minutes? If two documents are very relevant, that is almost all admitted.
Yeah.
So my appointment, I was just 2 minutes. I'll take minutes.
No. What was your prayer before the indictment?
My prayer is to approve my appointment and read the granting it under the 2009 as amended in 2014. I was appointed way back on 13/12/92.
13/12/92. Yes.
As a assistant librarian. That is the 4th post of assistant librarian in the college. Let me tell you, 4th post.
You were appointed to which post?
That 4th post. Fourth librarian post. 4th post.
There were 4 posts.
Yes.
4 vacancies.
4 vacancies.
1 vacancy you were appointed to.
No, last vacancy.
Last vacancy.
Yes.
4th vacancy.
4th vacancy. 4th post. I was appointed in 4th post. And the post was not admissible. That is also my admission. The post was not admissible by the date of appointment. Because 3rd post was admissible as per the relevant, as per the at stake.
Only 3 posts are
admissible. And not only admissible, the 3 posts were getting granted by that time. The college was an aided college. And by that time, 3 persons were getting granted. And 4th post was not admissible as per the work and at stake. That is also admission both. In the year 2001, on 2/1/2001, February, 1 person was retired.
So, 2001. Who retired? In which post he was?
Third post retired was getting granted. Sorry, first post retired, and the second and third are adjusted.
There were 4 posts of librarian cadre, of which 3 were admissible and admissible for and admitted to granted aid. First off, appellant came to be appointed. So the 4th vacancy on 13/12/1990. First, council very fairly submits that the 4th post not being admissible to grant was not admissible to grant.
As per the yardstick.
As per the
yardstick.
That's for the normative yardstick. First one. Next one. The incumbent of 3rd post, having attained the age of superannuation, retired from office on 2/1/2001. How he will retire on 2/1? He is not a constitutional post holder.
30, retired on
31/1.
31 on 2/1/2 I was adjusted. Just
1/1/2001. Then what happened?
Then I was adjusted with effect from 1/2/2001 by the governing body.
So the said vacancy, petitioner was accommodated by the committee resolution dated. Where is the resolution?
3/2/2001 under Annexure 2, page
3/2/2001. Annexure 2. What does it read?
That consequent upon retirement of Sri Madan Mohan Das, librarian. Madhusudan Palita, assistant librarian.
Madan Mohan or Madhusudan?
No, Madan Mohan retired, Madhusudan elevated to higher post, I was adjusted in assistant librarian post. You should kindly see page 12, Annexure 2.
12.
Page 12, Annexure 2, that is also admission of powers. That is no dispute.
Madhusudan retired.
Madhusudan, first the Madan Mohan Das, librarian, So assistant librarian is adjusted against the post of graduate librarian, and Ramakant petitioner is adjusted against the post of assistant librarian. The librarian took retirement, the assistant librarian promoted to the post of librarian, and I was adjusted as the assistant librarian.
Against the post of assistant librarian.
Assistant librarian.
What were you earlier?
Assistant librarian. Now I am claiming that retained as an assistant librarian, not librarian, because librarian is higher post.
With effect from 1/2/2000.
And page 59, you also can just have
This is approved.
By the management.
Management approved.
Yes, yes. No, everything is admitted. Nothing.
No, I want.
Yes, yes. That is approved.
When it is.
No, that is there. That resolution itself similar. That order is there. 3/2/2001. There is sub-collector being the president of the governing body approved it. That is the sub-collector order.
The sub-collector is said to have approved this adjustment.
Under Annexure 2.
Annexure 2.
Yes.
Sub-collector's order.
Yes, yes. Sub-collector signature is there.
Wide order date is
3/2/2001.
3/2/2001 Annexure 2.
And the principal filed the counter millets. Principal. And on page 60, page 59, that is clearly reflected when the person was appointed, when the first person is retired, and when has adjusted, and last adjustment, that is also accepted. By filing counter. And then millets, in 2007,
counter filed in your appeal.
In the GI application.
In GI application.
GI application.
For the tribunal.
For the tribunals. And what about millets in 2000? Yes, yes, sir.
Function submits that
the principal, the governing
body. The GIA appeal.
GIA petition.
Case. GIA case. The principal of the institution, being OP, had filed his objection admitting this position. Okay. Then what happened?
In 2007, the existing assistant librarian superannuated. So only the assistant librarian, the petitioner, continued till retirement 2024. From 2007 to 2024, the petitioner was the only assistant librarian in that college. Then millets.
When your client retired?
2024.
The appellant retired from the third post of assistant librarian with effect from
3/1/2001 to.
Okay, that you will do. It must be 31/1 or it must be 28/2. It cannot be any other date.
No, from 1/2. He was 31, he was retired. From 1/2, I am continuing. 31
January he retired.
January.
Come now already.
Yes.
And their client is still in service.
No. On 35/24, I took retirement. In the month of May 24.
Therefore, I asked, when you said some other day.
No.
I don't it only constitution.
Yes. That's
alone retire.
In a specific date.
In the mid.
In a specific date.
The specific.
And all others are in the month of.
Others are at the
end of the month.
Calendar month. Yes.
But then I approached the authorities for recommendation of a name for receiving grant in aid. The principal recommended, and the director sought information, and the principal submitted the information. Despite that, no action was taken. So I approached the Hon'Ble Court. The Hon'Ble Court directed to consider, and thereafter,
the request of the petitioner for admitting the post in question. Post was admitted to.
No, post was very much available. So that was no dispute.
Admitting him to the grant in aid, the post in question having already been admitted there too, was not considered, and therefore the file WP number. WP number?
Just one.
Fine. So wherein a coordinate bench of this court directed consideration by the order dated. Right. So just we have to look into that.
Double petition number 22067 2017.
22067 2017 disposed upon.
Disposed date is not in.
Verified from the computer. Put it there. Yes, then.
Then after disposal, the director sought information from the principal.
Principal gave the information.
Gave the information. Despite that, no action was taken. So I approached the tribunal for releasing granting aid by filing a J application. And the J application, they filed their counters. The principal filed the counter, the government filed the counter. The government said, we have already rejected a case. The government said. And what is the ground? The ground is, my lords, I was appointed in 1992. In the year 1998, the government issued a circular prohibiting the principal or the governing body to appoint anybody as long as the vacancy caused due to retirement or death. That the prohibition is there. And accordingly, I am not eligible because I was adjusted in 2001. That's it. 92 I was appointed. In 98 there is a circular that prohibiting the governing body to appoint or adjust anybody as long as the vacancy caused due to death or retirement. And accordingly, as because there is a ban and I was adjusted in 2001, accordingly I am not entitled to get the vaccine. That is their stance. So I approached the tribunals. Now the tribunals not accepted this. My argument was, in the year 2014, the rule was amended. And it is specifically stated, also this is very relevant. Kindly say page 13. Yes. That is the rules. Only I am relying this and the tribunal also relying this. And what is the interpretation also only interpretation. Kindly see page 13, annexure 3.
1 second.
Annexure 3, page 13.
Submits that during the relevant period when he was adjusted to the vacancy in the third post, the incumbent having been retired, there was a government order prohibiting appointment or adjustment of the kind.
That is order number 18707/HC dated 2498. The counter filed by the government stating that in that.
Say it slowly.
Yes. Order number 18707/HC dated 2498.
And it's
that page 42. Kindly see page 42. I may permit to read it. Page 42 of the counter filed by the government. That has been quoted. Government counter. Page 42. All the vacancy of teaching and non-teaching staff arising after 1498, either caused due to promotion, retirement, death, resignation, etc., shall not be filled up until further orders. In case there is severe dislocation to normal academic works, proposal for filling of these posts shall require clearance of the state government.
They said they will not approve the appointment.
Nobody will be appointed as the vacancies. Nobody. So there is prohibition. There is ban orders. But what the government said, and accordingly, my application was rejected. But my stand was there. I am relying the notification dated 22nd August 2024. That is the amendment of 2009 granting aid order, which is statutory in nature. And my stand was, you also kindly see, there was a provision, specific provision, that if the vacancy caused due to death or retirement and any person appointed, they will get the granting aid. That is there. Just for Lordship's convenience, I also kindly see page 13, annexure 3. Or I may permit you to read, Lords.
So
my argument was the statutory provision.
You should allow the judge to.
Oh, Lord, sorry. Excuse me.
This judge is not that.
No. See, you're still intelligent. Everyone knows, Lords.
No, I have to process it, na. If you say something, a dozen judgments run in my brain.
Obviously,
judgment it fits into paternalistically.
Yes.
So your case is the government order is liable to be ignored because of statutory.
Statutory, that has been also considered by the tribunal and also given in my favor. That is also given in my favor. And how that only one line, my lord, the interpretation is, my lord, the tribunal accepted everything. Yes, that 98, that's executive instruction and override the statute. and statute 1 said that you are also eligible. But they interpreted in this way. Let's kindly see page 13. Page 13, that is very relevant for lawsuit success. 1.3, that is the government notification, that is the rules. But by in which way this tribunal interpreted and how I am interpreting and what is the lawsuit acceptance, that is the only matters.
What is this? This is an order.
Yes, that is LOCC that granted in order 2009 in exercise of power conferred by subsection 4 section 7C of the Orissa Education Act. The state government do have to make the following orders to amend such a granted in order 2009. This order may be called 2014 para 2. The Orissa Education section says after the provision para 4, the following provisions and notes shall be inserted, provided further that the post of educational institution which are admissible by 1st June 1998 in education advanced district, we are considered 98. Such and such are high secondary schools or something such and such lawfully and filled up. The period from 1st June 98 to 1st June 2003 due to vacancy caused on account of death, resignation or retirement or otherwise of the incumbent shall be considered to receive granted by way of block grant. Now here this what according to my understanding,
yes.
If the vacancy caused will not in between 1st June 98 to 1st
June 2003,
and anybody appointed adjusted whatever may be, they is entitled to get the granted. So far the ban order that is practically lifted. This is my argument rather than accepted.
Ban order is dated?
That is 98. That letter I have given. I am just giving. 24. No, that is 24. 204. 2498.
20 April.
20th April.
Where is that copy?
That is been quoted by the government. That is in the counter that has been quoted. That is page 42. You know, kindly see.
Now, what tribunal?
Tribunal said yes, that cannot override the statute. The statute will override the executive instruction. So accordingly, that appointment is valid. That has been accepted. But the tribunal interprets other way. But what is the interpretation? Let's kindly see. The tribunal said that the post must be admissible by 1st June 98. You know, admitted my post is not admissible by 1st June. Accordingly, I was adjusted in third post. And so far the third post is admissible.
You were appointed to the fourth post.
Fourth post.
You were adjusted to the third post after the incumbent of that post retired on attaining age of superannuation.
Yes.
That post was already admitted to the
admitted, nobody disputes. That is admissible post.
But government order said nobody shall be appointed nor adjusted.
As again, the vacancy caused due to death, retirement, or whatever it will be.
And that vacancy was caused because of death,
retirement. Retirement.
Who appears for the other side?
Government. Government.
How brother?
Alright, may I read the same notification once again?
Read.
Provided that page 13.
1.3.
Yes.
Provided that.
The post of
provided further that.
Provided further that.
Why is he saying further? Because there is another proviso.
Yes, madam.
There must be, which is that proviso, let us say.
That 2009 GI order, that
2009 GI order.
2009 para 4, that is amended.
After proviso to para 4, the following provisions are null.
1 second. Provided further that means, provided that proviso is there.
Another proviso.
Another proviso is there.
In addition to that, this.
No, that is there.
Where is that proviso? This must be the second
amendment.
Second proviso.
Second proviso.
How the first proviso reads. Whether second proviso can be an exception to the first proviso.
2009.
That question also will arise now. Because there can be a proviso to the proviso.
Added college, added junior college, and added higher secondary college. Huh? Proviso for.
What is the first proviso?
Page 401 of the book.
Kindly read.
I read.
Get a xerox of that here. 1 second. Give that book. You will get a xerox of.
No, this book is available with me.
My lordship is available.
Give.
The admissibility of the block grant. I'm reading the entire book.
The first proviso.
Just two parameters. Just employees of the category mentioned in para 3 appointed prior to impositions of that.
Yes. That is yes. Next.
Fourth, admissibility of the post to block grant.
Employees of the categories mentioned in para 3 appointed prior to imposition of that.
Then that 20th April.
Here education department by letter number. It shall be entitled to receive granting by way of block grants determined in the manner provided in para 5, provided that in the educational service para 3, where one stream, arts, science, and commerce, had been admitted into the granting area. Subsequently, other streams of have been opened with governmental recognition of this, including the first two miscellaneous for the second policy. The additional courts which were admissible. First proviso is not applicable.
Not applicable. For last thing, I am relying
second proviso is not there here in this one.
No, that is also amended in 2000. That was brought by of amendment.
Okay, so in this book it is not contained.
No, it is not there. Subsequent letter. No, that is not there. That was written 22nd August 2014. And the interpretation errors.
Provided further that, in addition to
correct first proviso. Therefore, this proviso is not a proviso to the first proviso. This is a proviso to the section to which first proviso is appended. Correct?
Yes.
Do you agree with that proposition? Now read.
Aided educational institutions which are admissible by the 1st June 1998 in educationally advanced district and by the 1st June of 2000 in educational backward district, including the first women, junior college or higher secondary.
No, you have put the comma elsewhere. 1st June 1988 in educationally advanced districts, comma.
Yes, and
by the 1st June 2000 in additional educationally backward. In which one you will fit into?
General districts. Not that one.
That is 16/2000.
No. 16 is special method. That is 98.
16.
Last one is 98.
That is for general.
Educationally advanced.
Advanced district. My district is educational advanced district.
Or higher secondary school or women's college of a subdivision and validly and lawfully
filled up
during the period from the 1st June 1998
June 2003
to 2003.
But he fits into that timeline.
But due to vacancy caused on account of death, resignation
or retirement. 3, it fits into that also, Mr. Monti.
Death, resignation and retirement.
Because the third vacancy retired, third incumbent retired.
Shall be considered to receive JA by way of a block grant. Coming to the page, my lord, 91 for a moment. That is the
I want to understand what is meant by this.
So the present petition on my lord, so far this date is concerned 24/1998. 20th April, my lord.
His appointment.
That is the embargo, the date.
Government order.
Government.
Ban order.
Ban order.
Correct.
So, admittedly, the college being situated in Bhadrak, this is in advanced district manner, this cannot be backward district manner.
Correct.
That exactly has been pointed out in the order itself, my lord. Must show that the post held by him in admissible by 1/6/1998, my lord.
Held by him.
Yes. But he was the assistant librarian received the approval by the sub-collector in 3/2/2001.
May not be correct.
May I read him, my lord?
Under your rules,
Yes, ma'am.
post is admitted to grant in aid. Then incumbent is also sanctioned grant in aid. Two things are there. Admission of the post itself to the grant in aid.
And the
appointment, approval, other things, etc. is another. If a person is appointed to the post which has been admitted to the grant in aid, then he will be entitled to draw the salary in the grant and the government will pay the salary.
Yes.
Subject to approval, etc., etc. Once he is adjusted to the third vacancy, which earlier he was holding fourth vacancy. For fourth vacancy, there is no provision for admitting at all to the grant at all. But third post is admitted to the grant. Do you dispute that proposition?
My lord, exactly, that has been clarified. I am just reading out for a moment. Page 91 for a moment.
91.
Yes, ma'am. Of the brief, ma'am.
This is by 1619, but here in this.
Or he also quoted there, no?
Post held by M is admissible by 161998.
1698. But
yeah, it was admissible to grant. It was admitted to grant which year?
The
post.
Third post will also 77-78. That is also admission. That principal has filed stating there.
But here it is held by M is admitted to grant.
That is also the finding.
See this. Not he is approved, etc. Post, whether it is somebody is appointed or not, you just forget that. Incumbent is not our focal point.
Post.
The focal point of this is version of whom? The tribunal.
Yes, ma'am. Tribunal has found.
The tribunal finding.
Tribunal finding.
The third poster is admitted to grant decades ago.
98.
Not 98, much before that. It was admitted to grant in which year?
The third post, 77-78 millers.
Yes.
Yeah, that person retired millers. 2007.
Post of assistant type received the approval of the sub-collector. Here in this case, the applicant's post of assistant type received the approval of the sub-collector. This is wrong. So, what you should see is whether the post in question was admitted to grant as on this particular date or not. Subsequently, so many people will join, retire, resign, die away.
And they have been adjusted against the post.
So the difference between admission of a post to grant and appointment to the said post, this he got confused with each other.
He has been adjusted against that post.
That post is
after the demise of form.
Therefore, he is saying everything is admitted. But when it comes to adjustment, I entered the third post, which was already admitted to grant because the incumbent was drawing the salary on the basis of the grant itself. Therefore, whatever is payable to him is payable to this person is committed.
So, as he has been adjusted in 2001.
Even when he was adjusted, the post was already admitted to the grant in airport. He mistook date of appointment being relevant.
Yes.
When date of appointment is not being relevant. Relevant thing is when the post was admitted to the grant. You see that the section itself reads that way. When your post was never admitted to grant at all because it was fourth post.
Also never admitted, no, admitted.
Not admissible by all.
Where is the material to show that the third post was admitted to grant?
Let the finding of the London tribunal itself says, and that apart, the principal. Yes,
Says negatively in para 11.
No. It also particular place.
So leave what the tribunal says. Show it independently because you have put the order of the tribunal in challenge.
That is the
so independently you show the material.
That is the admission of the principal by filing the counter because records are available with the principal and the government. And the government also says, that government has not disputed because so far I am saying the government. You kindly see one thing. Kindly see what is the page 38. Let's kindly see page 38. Page 38 the relevant.
38.
Yes. What is the rejection? What is the ground in rejecting my claim? Let's kindly see this is the rejection order.
This is not legible to me.
38 page. Annex 7.
No, 38 page is not legible. 38 and 39. Annex 7.
Do you have print copy?
Yes. My I think that is very clear in my view.
Perhaps
take up.
It was xeroxed by vanishing ink. What is this paragraph? Which
para 2 and 3, I think they're very relevant.
2 and 3. Unnumbered paragraph? No, 2 and 3.
These are all only the short paragraph.
The 77 years.
University joined on 30/12/92 as Assistant Librarian. The Governor College approved the appointment of such and such. As per the provided 17/6, non-teaching post of graduate librarian are admissible to the college when the students in such and such. But auxiliary college, one graduate librarian, one graduate are already included in the fold. The third post is not admissible. Fourth post, as per the asterisk. Then next. After retirement of graduate librarian, one non-graduate librarian was promoted to the post of graduate librarian with effect from such and such. I directed office order.
What is this? This is the order.
This is the order rejection of the government.
Which you had put in challenge before the
tribunals. And the see what is the ground? Now you see what is the stand. And that has been negative by the tribunal. But the tribunal interprets the rules in some other way. That has been negative.
No, not only that. The impugned order, para 2, last 2 lines. The order, page 38, the order which you had put in challenge before the tribunal under 24B perhaps. 24B. Go to that 24B order, that order which you are now holding, na?
Yes.
This order is dated 5/7/2022.
Yes.
You had put in examination under 24B. Correct. Come to the last 2 lines in the said order, which you were holding now.
Yes, Lord.
Yeah. The post held by the petitioner is a 4th post, and the said post is not admissible to the college as per the act. This itself is wrong. This appears to be wrong.
Well, that
the post which you held earlier was that one.
Earlier, if
adjustment
had it been admissible post, I could have got granted under that clause 4.
Correct.
Because the clause 4 says that those who are appointed prior to 98, they will get. I was that was not given by applying clause 4, and only after amendment I became eligible.
Mr. Modi, do you have a copy of this order?
Well, that is not eligible one.
No, take.
I have got that annexer 7.
Last 2 lines you read, that appears to be wrong. That's the reason he is saying that even tribunal erred. He treated the petitioner, the appellant herein, as the incumbent of 4th post. There are 4 posts of library in that cadre. Post 1, post 2, post 3, post 4. Post 4 he was holding when he gave degree. Subsequently, the incumbent of post 3 retired. Vacancy arose. To that vacancy, he was adjusted. He was adjusted to the post which was admitted to the granting date. And therefore, the premise on which the order is made by the director, who made this order?
This is a principal secretary of the government.
Appears to be wrong.
272.
They ignored, their only contention is either they have ignored that he was adjusted to the post, or they went on the assumption that there was a ban, therefore he could not have been adjusted. You cannot have a ban against a statute. Your orders, your executive instructions cannot run a race of competition with the statutory provision.
Yeah, obviously. That cannot occur. Check copy.
That should be allowed.
What are notes to file? Today file a note to that effect, my lord.
I heard other matter, I heard this matter.
Oh, Monday.
He wants to file.
And the legible copy be supplied one copy by that.
Of the short of sickness of the papers. Comma. The essential facts are these. There were 4 posts of librarian in the college in question. First, petitioner was appointed to the 4th post. Vacancy in the 4th post. First, wide order dated 13/12/92, you said.
Yes, that is.
First, the incumbent of 3rd post having retired on attaining the age of superannuation on 31/1.
31/1.
Here.
31/2001. 31/2001. Sorry, 31/1.
31/1/2001.
That is 1 day wrong.
Comma. The vacancy accrued. And to the eventual vacancy, petitioner came to be adjusted. Why what is called management board, or what is that?
Management post.
By the board of management.
Why the board of management?
Why resolution dated?
3/2/2001.
1 to
May not be 3/2. There will be again vacuum. It must be 1/2.
This is 1 to 2001.
No, with effect from 1/2.
Subsequently with
effect from 3/2 by order dated 3/2 with effect from 1/2.
You are right. 3/2/2001.
Under Annex 2.
With retrospective effect from 1/2/2001.
Under Annex 2.
First one. Petitioner's claim for granting aid facility was negative on the ground that such an adjustment would not have been made because of the government's ban order dated.
This is 24 1998.
20 April.
First. This was put in challenge by the petitioner under section 24B of the 1969 Act, and the tribunal negatived the challenge, agreeing with the submission of the government that the post held by the petitioner was the 4th one, and even otherwise his adjustment to the 3rd post was not permissible because of the ban of appointment or adjustment to the vacancies arising by virtue of retirement, resignation, death, or removal.
etc.
Yes. Next one. Learned counsel for the appellant submits that once adjustment happened, petitioner, the appellant, his client was holding the 3rd post, which was already admitted to the granting aid. And therefore, the ban would not arise in the light of, in the teeth of, which section it is, which rule?
That 2009 as amended 2014. That is, that rule is, let's say that Annex 3. That rule called the Orissa Aided College, Aided Junior College, and Aided Higher Secondary 1998 Amendment Order 2014. Page 13, Annex 3.
Page 13, that gazette is there.
Gazette is there, Annex
3.
Annex 3.
Published by notification date
2nd August 2014.
Yes, you put it this much. Okay, by way of notes. All right. So this you have to answer. If you want, you can have the draft copy.
Yes, I can tell.
Share copy or not. No. Just give a copy to both of them. Tomorrow.
Tomorrow.
things have to be accomplished before the memory fades.
Monday.
There is a famous book, do you remember? Before memory fades. Whose book?
Justice, sorry, Palina.
Yes, Madam Pan.
This is an item 76, your lordship.
Article केंद्रीय होगा slum matter. Justice Nagaprasad के judgment. Your lordship. Your lordship, slum dwelling matter. 66 item. 61. 66 or 61? 61. 66 is a slum dwelling matter. CDA, Chapter 8. Your lordship pointed out that Honorable Justice Nagaprasad judgment totally covered. And the review petition Supreme Court judgment at the lordship hiding part also. Lordship picks up any date. Why they are taking time?
It is already urgent in the morning when you were not here.
Well, they are taking such free and yes. All right, your lordship, whatever.
Which date? To accept. Any date is
Date fixed time.
sign now.
Yes, I don't.
Lordship may fix a date.
Sign.
If order is signed, I cannot. If order is not signed, I will put a date.
Only the date may calculate.
That's what.
My lord.
61 the petitioner is also discharging duty but not getting the salary. Tomorrow or that.
Which serial number?
61.
Sir, all
Item 76, your lordships, it's that Sanskrit and that Hindi recruitment matter. Your lordships yesterday have vacated and allowed the appointments to happen also. Your lordships, we also have quite a similar period. This can be taken up tomorrow, the first 5 matters then.
Tomorrow we have difficulty.
Monday, your lordships.
Can you have it next week?
Yes, next week.
My lord.
In item number 76.
My lord.
In item number 76.
Yes, madam, we'll have it next week.
In item number 76, in this very item 76, I have filed intervention application. Let those intervention application be called.
Registry to post all pending applications.
Obliged.
My application is pending.
Item 76.
62, my lord. On my mention matter was registered, I am going without salary, my lord. In next week, any date, my lord. Any date.
Next week we have difficult. In the second week of December.
Item 70. Item 76. Item 70. Item 74. 74. Let it come tomorrow. They have not complied with your lordship's order for not release this essay from 2023. I am without salary. For that reason,
8th of December.
Monday of fresh admission, not release salary, my lord. Your lordship directed. So that it will reach.
My lord, item 15N.
So that it will reach, my lord. The last 2 weeks I am voting, my lord. Had a press admission.
Item 76, lordship.
If wherever there is entry model continuing till next week.
My lord, item
15 matters. So that's there should not be more than 10 matters of the day which you already fixed. More than 10 it should not be. Which is below the 10. You accommodate them based upon urgency.
65 pencil matters. Item 6.